Good morning. This is the sentencing of the Parkland school shooter. The fate of the defendant is in the jury's hands. They started deliberating yesterday. Let's listen.
Way you would be able to tell is if you were rather skilled in firearms and you took it apart and looked at the insides and knew what you were looking for. And obviously they're not going to do that. So that is, I think, a pretty reasonable compromise. We're going to go ahead and Deputy Politano has the, just to show you all, the firing pin has been placed in an evidence envelope, and that was all done in the presence of the clerk in the evidence room. So we're going to keep that separate. Maybe we can make it, what is the exhibit number for the gun? Okay, they're saying they're going to put the firing pin back in at the end.
Yes.
So that it's, I guess, made whole. All right. With that, if we can please bring, and the jurors are not here yet, so the gun will be there for them when they are waiting for them when they return, which should be momentarily.
That's good.
Is there any other questions or concerns or anything that we need to discuss this morning?
No, Your Honor.
Good. On behalf of the state, we have no objection to them just be taken into the jury room to begin their deliberations. I don't think we need to reassemble.
I agree. Defense, do you agree?
Yes, that's fine.
Okay, we'll call you if there's a question or any matter that needs to be addressed, okay?
Thank you.
All right, thank you.
Thank you, Your Honor.
Thank you.
So there was some question yesterday. The jurors had asked the judge if they could see the murder weapon, that AR-style rifle. You can see inside the courtroom the picture has frozen just a little bit, but there's the defendant, there is his defense team. They have wanted to see that murder weapon, and today it was agreed upon that they could. They're going to remove the firing pin. Initially, they were going to bring this jury into the courtroom to reassemble, but the judge and the attorneys agreed that wasn't necessary. You can look inside the gallery of the courtroom right now. You can see the family members speaking. A lot of these, the core family members that have been there since just about the very beginning. You can see Patricia Oliver. You can see the Hoyer family is there as well. Scott Beagle's parents, his mother, and then his adoptive father, who have really been wanting to bear witness to what's been happening so that they can see firsthand every single moment of the activity inside the courtroom. You can see the defendant is still sitting down, wearing a mask over his chin. Over the last few days, he has not looked very engaged. His head has been down. It's been in his hands. He's right there once again with his defense team. So presumably he gets brought in, and then according to those who are familiar with what happens in the courtroom, he then gets brought back out into his holding cell, which is where he is for most of the duration of the day. You can see he's being ushered out right now by Broward County Sheriff deputies. So once again, we have learned that these jurors will be looking at the murder weapon, this AR-style rifle that the defendant had purchased legally, by the way, before he committed the crime February 14th, 2018. The defendant waiting there, you can see that's the state team following some of the family members out. So at this point now, we just wait. The jury will come in. We've been told by the judge that not all of them are ready yet. Sometimes there's traffic. You never know what's going to happen when you have 12 people. What we understand is they were in their hotel last night. They were sequestered. They weren't allowed to speak to anybody. They weren't allowed to look at phones or anything electronic. And then this morning, they come in together as a unit. They get brought in by the Broward Sheriff's Office, and once they do, instead of reporting to the courtroom as we initially thought would happen, they will be taken into the jury deliberation room where they will see that murder weapon and they will continue to deliberate. They started yesterday just before 11 o'clock in the morning. They had a couple of questions. They wanted to hear some of the testimony of one of the defense witnesses. In fact, they wanted to hear testimony from two opposing expert witnesses who both had analyzed this defendant, Nikolas Cruz, in the jail for several hours. One of the witnesses, of course, saying that he believed through his research that the defendant suffered from fetal alcohol spectrum disorder. The other state's witness, of course, the rebuttal witness, said that's not the case at all. He actually scored quite well on some of these tests if you look at all of the data. So these two opposing witnesses, the jury wanted to hear from both of them. They ended up just hearing the cross-examination of the defense witness, and then they said, we're done. So what that means, we just don't know. So once again, looking at sort of the live picture now from the courtroom, you can see the seal of the state of Florida is up. That means that there is no open court. The jury will be in that deliberating room. They will be doing their thing, and as soon as there's any activity, as soon as there's any motion, if there's a question by the jury, and of course, if there is a verdict, we will bring it to you live. We'll be here every step of the way, and we'll see you then.
She has been watching every moment as well. Janine is joining our coverage right now. Janine, what do you think is the process here in the next few minutes before they make the official announcement at 10:30?
We understand that the watchers a chance to go inside the courtroom, to sit down, to be able to bear witness to this. So I think they had announced all along that they would be giving everybody about an hour to sort of get in place, to get the attorneys in place. As you mentioned, Eric, the jurors wanted to see that murder weapon. The question is why? Is it because they wanted to see how heavy it was? Is it because they wanted to compare the murder weapon and what it takes to hold a big AR-style rifle like that with the, defense's contention that the defendant did not have good fine motor skills? Did they want to look at that? Did they want to see exactly what was used to maybe help them either confirm what they had believed all along or to maybe perhaps be part of their mitigating circumstances? So we just don't know yet. But again, 10:30 this morning is when we do expect the jury to come back in and for them to make their announcement. And Eric, you and I were talking about this. Remember, this is not a guilt or innocence phase of the trial. He already pleaded guilty to 17 counts of first-degree murder, 17 counts of attempted first-degree murder. This is life or death. And because of that, these jurors don't have to be unanimous. They do when it comes to each individual case of death, but they can vote individually. They can vote how they want. And so the question is, what's going to happen? Does this jury coming back relatively quickly, about an hour, does this mean that that they are all on the same page? We just don't know. My colleague Christina Vasquez, she's been in there every step of the way. She's actually had a chance to witness and observe these jurors. Christina, what do you think?
One thing to say about the course of this entire trial, and you've heard me mention it before, is just how diligent these jurors have been. You've noted my observations in terms of the jurors being attentive, so many of them engaged in note-taking. What we know at this moment in time is they entered into these deliberations at about 10:44 a.m. yesterday. They wrapped up at just about 5 p.m., and you may remember the deliberations ended shortly after they made a request to view the AR-15 style rifle the Parkland shooter used to gun down students and staff on Valentine's Day 2018. You may recall that that request was not able to be honored in that exact moment, and that is because the judge telling the attorneys that BSO had not set up the proper safety protocols in order to bring that firearm back to the jury room. She said, we'll reconvene in the morning. This morning, then we get to the start of this morning, very swiftly, very succinctly, the judge says we found a solution. We're taking that firing pin out, and that firearm is going back. And shortly after that, it's when we get word confirmed. I spoke to the chief judge's office, and as well I confirmed to the Broward State Attorney's office that this jury has a verdict that they are ready to deliver. And that moment is going to happen, I am told, at 10:30 a.m. As you can imagine, this gives some time for the family members to arrive, to be able to hear what this jury has decided. And remember that this verdict is going to be nuanced. In fact, actually in my hands right here, just to give you kind of a little bit of a show and tell, this is just one count. This is count one. This is Luke Hoyer's count. There are 17 counts in this capital case, one count per one victim. There were 17 who were killed, staff and students at Marjory Stoneman Douglas. It is Nikolas Cruz's guilty pleas to those murders on October 20th, 2021. So we're just days out from the 1-year anniversary where he entered in those guilty pleas, which set up this penalty phase. So when we talk about what you're about to expect when we go into it at 10:30 a.m. and it being nuanced, because there are 17 counts, what this jury was tasked to do is count by count, multiple pages, is first decide whether there's an aggravating factor that exists. Now, when you think of aggravating factor, this is built into state statute, but there are things like this act was committed in an especially heinous, atrocious, or cruel way, that it was cold, calculated, premeditated. Those are just examples of some of the aggravators. If they unanimously have decided that not just that an aggravating factor exists, but the state proved it beyond a reasonable doubt, then the state statute permits them to move to the second part of the form. That's why there's multiple pages to this form. And that's when, count by count, these jurors had to weigh the evidence. And that's an important term here, weighing the evidence, because they had to process the evidence that came from them through the state. You may remember we are talking about grisly and harrowing testimony from medical examiners detailing the tragic and horrific ways they died when those high velocity bullets just pierced through bones and tissue and organs. You may remember that was very difficult testimony. They also heard from survivors with first-person harrowing accounts about seeing their classmates die, about having to walk past Scott Beagle, who was laying dead, if you remember, half of his body in the hallway, half of his body in the classroom. Really difficult testimony. So they had to listen to all of that, and then they heard the defense case. And the defense gave them what they call mitigating circumstances. Another way to think about that is reasons for life, things that they can weigh and consider as they're looking at the totality of the case. And what the defense really wanted them to focus on is his background, right? What shaped their client? What shaped Nikolas Cruz? And so they spent a lot of time and a narrative that ran through from the lead defense attorney, Melissa McNeil's opening statement, through the witnesses they decided to present, dovetailing with a tale of two moms, if you remember, where they wanted the jurors to think about a birth mother that they said really abused alcohol and drugs while pregnant with Nikolas Cruz, telling them he has brain damage from being poisoned in the womb. And then they also spoke about another mother who has also since passed away, his adoptive mother, Linda Cruz, who they positioned as being a woman who was maybe well-intentioned even, but inept at being able to manage what their experts had said was underpinned his lifetime troubling pattern of aggression and anxiety, of fetal alcohol spectrum disorder. You had the state on rebuttal with its witnesses saying absolutely not. They say he has antisocial personality disorder. So those jurors are in there weighing all that, and then they have to individually decide life or death. And this is important here. This is a recommendation. It is actually the judge that will impose this sentence. The jury today will be saying whether they recommend life in prison without parole or death as the punishment. And when we talk about that, we also have to say for each count, 17 times, they have to be unanimous in a recommendation of death. So let's just take the count of Peter Wing, count 17. Let's say that 11 of those jurors in those rooms said, it is our individual belief, after weighing the evidence, that we believe death is the appropriate punishment, but just one believed it's life, then that would be life for that count. So we'll go by that count by count. Now let's look at the totality of the 17 counts, right? Let's say just on one count, they did find unanimously on that murder victim, that count, that death was the appropriate punishment, then that means he would be facing the death sentence for that one count. So that gives you a little bit of a roadmap as we get into the 10:30 a.m. hour. Back to you.
We just received news that the verdict will be read at 10:15, so that's about 20 minutes away. We are going to have more details on what that entails as we get closer to that 10:15 reading of the verdict, but right now we need to take a quick break and we'll be right back.
The Miami International Auto Show starts October 15th. Get your tickets now at MiamiAutoShows.com. Visit Camp Jeep and experience the first ever EV mobility track. Get your tickets now to test drive a new electric vehicle at MiamiAutoShows.com.
Annette Tadeo, spotted huddling with the Miami chapter of a socialist group that supports the Cuban communist regime. Tadeo joined them to rally support for socialist-style spending that could bankrupt the country. She supports paying people even more not to work and locking down those who do. The revolution won't be televised, but Tadeo's socialist ideas will.
This election will determine if we become a socialist dictatorship.
Congressional Leadership Fund is responsible for the content of this act.
I think he'll be safe in there.
Help keep what's important to you safe with Chevy Safety Assist, standard on these Chevy SUVs. Find new safe places, find new roads.
Well-qualified buyers can get 1.9% financing or get $1,200 cash allowance on all 2022 Equinox models. See your South Florida Chevy dealer.
My opponent attacks me using lies just to defend the extremist Washington agenda that's brought us rising gas prices and inflation that hurts working families the most. I'm Alexis Caladiud. I'm running to be your state senator because I believe in servant leadership that will fight for this community and take your concerns to Tallahassee. We need common sense solutions. I ask for your vote because together we'll get a lot more done.
Our doctors do three things extraordinarily well. First, they meet and engage with you as a person. Second, they want to understand your current medical need. And third, they collaborate with you to build a primary care plan that works for your health right now. Come and experience your very own My Care moment. That special feeling when you found a doctor that cares and connects with you. My Care Medical, quality care that follows you everywhere.
The Miami International Auto Show starts October 15th. Get your tickets now at MiamiAutoShows.com. Ride and Drive's new car reveals, Camp Jeep, and the all-new EV test track. Get your tickets while they last at MiamiAutoShows.com.
Local 10 Plus, a one-stop shop for all your news, weather, traffic, and sports. Plus home tours, recipes, and health tips from your favorite SoFlo shows. You want it, and we've got it all. Streaming on Roku, Apple TV, Amazon Fire, and many smart TVs. Only on Local 10 Plus.
You see this sticker? Before you get one of these, you have to do this.
Research the candidates. Go to local10.com to find your voting options. And then get out and vote.
Stick to a plan and pave the way for the future. Vote 2022.
We are back with breaking news. You see members of the victims' families there have gathered in that Fort Lauderdale courtroom. The verdict is in. The 12-member jury has reached a decision in whether or not the Parkland shooter will spend life in prison without the possibility of parole or will face the death penalty for those horrific murders that happened at that high school back in 2018.
We do have Syra Anwar. She is right outside the courtroom. She has been covering this case, especially as we had day one of the jury deliberation start yesterday. And today was the start of day two when we found word that there was a verdict that had already been reached and they would be announcing it just minutes away. Syra, when you talk about the deliberations that we watched and the questions that were asked, especially the desire to hold that gun and examine the gun that the school shooter used on that fateful day on Valentine's Day 4 years ago, when you see that they've already reached a verdict at this early hour in day two, I'm sure there is some idea that they were definitive in their answers that they were searching for.
Absolutely. We went into this not knowing how long these deliberations were going to take. 1 day, 2 days, a week. We were prepared no matter what the timeline was. But, you know, we found out just moments ago, Cristina Vasquez in the courtroom confirmed that they would be coming out with this verdict at 10:15. So, I mean, now we're prepared for whatever the jury has to say. But it does seem like they were able to reach a unanimous verdict to recommend to the judge here pretty quickly. So we do know that this morning they were finally able to see that key piece of evidence that they've been asking for, that AR-15 style rifle. And that was a point of contention yesterday in day one of these deliberations, where they requested to see that rifle. But BSO, Broward Sheriff's Office deputies, told the judge, hey, we're not ready to hand over that weapon. We don't have the protocol in place, even though it was an unloaded weapon. So there was a lot of back and forth with figuring out how to allow them to see that weapon, but they figured it out. They were able to see it this morning, and then just what seemed like moments later, they said they have a verdict. But let's give you a recap of how that all went down yesterday in day one of deliberations. On the first day of deliberation, jurors asking to see the weapon Nikolas Cruz used for the 17 murders during the 2018 Valentine's Day massacre at Marjorie Stoneman Douglas High School in Parkland.
It's absolutely preposterous.
That's the state prosecutor's reaction after being told by the judge that Broward Sheriff's deputies did not yet have protocol in place to fulfill the jury's request to see the rifle.
They're telling me for security reasons that they need to take some measures before they allow it. I have to stay in my lane.
They're jumping in your lane. You control what the jury sees, not the sheriff's office.
Unresolved, deliberation ended for the day.
Captain Tianga assures me that this will be taken care of before the jurors return in the morning so that it can be waiting for them in the morning.
It's certainly unusual for jurors to request that a piece of evidence, in this case a firearm, be brought into the jury room during deliberations, and for their request not to be honored.
Earlier in the day, the jury asked to revisit cross-examination of defense expert Dr. Paul Connor, who said Nikolas Cruz has mild to moderate memory impairment, fine motor speed, and executive functioning. Here's a playback of part of that questioning.
He appeared on the video goal-directed.
I have no opinion about that.
And dedicated to his task.
Answer, I have no opinion about that.
The jury initially also wanted to hear all of Dr. Robert Denny's testimony. That's the state rebuttal witness who was critical of Dr. Connor's findings and told jurors he believed the Parkland shooter was exaggerating his impairments. Jurors later telling the court they no longer needed to hear it.
It would appear that that mitigation issue, for the moment, has been put to rest.
So the jury returned here this morning at 8:30 to the Broward County Courthouse here in downtown Fort Lauderdale. 9 o'clock is when the attorneys arrived. They began those deliberations. We're told they were able to see the weapon. And then just half an hour later, we get this news again confirmed by Cristina Vasquez in the courtroom that they would be releasing the verdict at 10:30. Now that's been moved up to 10:15. So this all has been happening very fast this morning. Of course, we're remaining on top of it, waiting for that verdict to come out. But again, the feeling here is that they were able to unanimously reach a decision very quickly. This is only day two, only really less than an hour into deliberating this morning. So of course we're on top of it. We'll keep you updated. That's the latest live out here in Fort Lauderdale. JC and Eric, back to you.
Okay, Sarah, thank you. You see on your screen right now, that is the state, the prosecution team. They're all there waiting for the jury to read the verdict. We saw moments ago as Sarah was delivering that report, we saw the defense team also there in the courtroom. We're waiting for the judge. As you can see, take the camera here, who will come through those doors, we're not quite sure. But as we wait, we bring in back in our own Janine Stanwood. Janine, Cristina was starting to get into some of the details of what the jury will weigh for each of these 17 counts. Each one of the victims who was murdered that day will have a separate count that is decided by this jury. They make the recommendation of life in prison without the possibility of parole or the death penalty to the judge. What are the judge's responsibilities? What does the judge do from there?
Well, let's start with first what the jury has to do. And we just want to clarify, they only have to be unanimous on each count to recommend death. If they are looking at, for example, count one, Luke Hoyer, and Cristina had mentioned this too, and let's say, 10 of the jurors believe that the aggravators outweigh the mitigators and that he should be sentenced to death. But if there are two others who don't believe that way, if they cannot reach a consensus, that's okay. That doesn't mean there's a hung jury. They can make their individual votes. That means that for count one, the recommendation is life. So the unanimous part really only has to be for a death recommendation for each of these 17 counts. They are considered to be separate counts. So that's the first thing that happens. Let's say that for all 17 counts, every juror is recommending death. Then that goes to the judge. Now, under Florida statute, the judge can in sort of layman's terms, downgrade it. She can look at the evidence, because this is just a recommendation, and she can say, my judgment is that the defendant actually deserves life in prison without the possibility of parole, which is what he had pleaded to. Then that can happen. The other way cannot happen under Florida statute. So if it is recommended that indeed the defendant should spend the rest of his life in prison without the possibility of parole and not death, the judge can't upgrade that. So that is kind of the way that happens. So first things first, though, we're going to wait and see what this jury is recommended. You can see there's Lori Alhadeff. She's in the courtroom. A lot of these family members, Eric and JC, we have talked about this. It's tough for them. Lori Alhadeff, in fact, just yesterday, when there were closing arguments, she left the courtroom. She was extremely emotional. This has been a very tough time for these parents, but many have said to me personally and my colleagues here at Local 10 that they want to be there because they want to bear witness. That's Chris Hickson's son, Debbie Hickson's son. You might remember during victim impact statements, he made a very, very powerful statement when he was asked about his dad, and he simply said, "I miss him." And it had the whole courtroom in tears, including the defense attorneys. That's another thing to keep in mind. Those victim impact statements, as emotional as they were, the jurors, of course, can weigh those, but not look at those victim impact statements as aggravating factors. Again, this is just under Florida statute. They, of course, can look at those in the totality of the decision that they make, but those are not aggravating factors. Ian Margol is also in Fort Lauderdale right now. He's been sort of taking the temperature of what's going on. Ian, what's happening where you are?
So we are standing in here. Our colleague Christina Vasquez has actually walked into the courtroom to be there when they make this announcement. But we can tell you guys, as we've been saying all morning long, they have come to a decision. The jury, they're going to be announcing their decision, their recommendations to the judge in about 30 minutes at 10:30, about 25 minutes from now. They announced that they had come to a decision about 35 minutes ago, so right around 9:30. The judge wanted to give people time, family members, attorneys, everybody else time to gather and eventually get here to make sure everybody was there for when the jury did announce their recommendations. Yeah. What we've been seeing, Janine, as you mentioned, was that
Ian,
there have
I don't
been
want
family
to
members.
interrupt you, but I just want to make sure everybody's aware that
Please.
has been moved to 10:15. So I know you're just joining us, but I don't want to lose any of our
10:15.
viewers because
Thank
we're on
you.
standby 9 minutes and counting. So just don't want to lose anybody thinking they have until 10:30. We are expecting that verdict to be read in less than 9 minutes at 10:15.
Thank you, JC. We appreciate that. Being down in the hallway, things a little bit slower to come out this way. I know you guys are getting updates a little bit more quickly through email, things like that. So thank you for that. But as we mentioned, jurors came in about, they came in 8:30 this morning. About an hour later, announced that they had made a decision. And as Janine was explaining, they just make a recommendation on each of these 17 counts about whether or not they believe Nikolas Cruz should get death penalty or life in prison. And again, these are just recommendations to the judge. The judge then imposes that sentence using those recommendations from the jury. And I know that we had been speaking about this the entire time this morning, sort of explaining how this all works, but just to reiterate one more time, this doesn't need to be unanimous on all 17 counts. It is individual 17 counts for each of these people who was killed that the jury can then come back and make a recommendation on life in prison or death. And again, it does need to be unanimous for death. So right now we are out in the hallway, Christina Vasquez inside the courtroom, waiting to hear the jury give their decision. We'll continue to bring you updates from here in the courtroom. Guys.
All right, Ian, we appreciate that update. And of course, we're on standby waiting for this verdict to be read, just minutes away. And we also want to talk about, since we're going into great detail on what this entails, and we've really learned a lot about Florida statutes and the court system as we followed this case, this penalty phase of the school shooter's trial. We do know he's pled guilty to those 17 counts. And we have Janine with us. And Janine, the other thing I wanted to mention, you've been watching this case for months along with Christina. When you talk about that judge who does have the potential, even after the jury makes their decision, makes their verdict, the judge can change it in terms of downgrading, not increasing. What have you seen from the judge in all these months as far as what does it look like? Does it look like she's a judge that would stick to what the jurors chose together? Or is she going to be a judge that makes her own decision? Just from, I know we don't have a magic 8 ball, but just in our observance for so long, how she carries her courtroom.
Well, she has even said on the record that this is her first capital case. And so we just don't know. As you know, there has been some contention, at least the appearance of that, between her and some of the defense attorneys, but that doesn't mean that she has a judgment one way or another. So I think it's yet to be seen. Now, if the jury recommends death, would she say, well, she would downgrade it and instead impose a life sentence once the jury has recommended death? In Broward County, where this happened, pretty doubtful. So we're just going to have to wait and see what happens. And another thing, JC, that I want to bring up, and as we are all looking in the gallery at these family members, when this whole thing started, it is hard to believe it's been 3 months with more than 100 witnesses, hundreds of pieces of evidence. So many of these families have been there every step of the way. They've been incredibly emotional, but incredibly strong to be here every step of the way. It is just one thing to look at who these people are sitting in the gallery every single day. And many of these families have mentioned this from the very beginning, that although they don't want to maybe speak that openly to the media as all of this is happening, they have wanted to remind the community what this is all about. To many of these family members, this isn't about the actions of the defendant necessarily. This is about what happened to their loved ones who are no longer with us here in South Florida, here in the world. This is an incredible sense of loss. And no matter what happens today, no matter what verdict is rendered, it is hard to imagine that this will bring any semblance of closure or normalcy to these family members. Not at all. But this, at least for them, and many of them have told us that this is perhaps a sense of justice. This is an opportunity for the world to see what happened with this defendant and perhaps changes in the community. And as you know, they have already been made since this massacre happened. Craig Tricino, who has been our legal analyst for many, many months, grateful to have his expertise from the University of Miami. I do believe he is either on Zoom or is he on the phone with us, but I think he is on Zoom. Craig, what does this say to you that now, after less than 24 hours, the jury has come to a verdict?
Hi, Janine. Yeah, it's a relatively quick verdict given the length of the trial and the amount of evidence the jury had to sift through on here. But I learned a long time ago not to try and divine what the jury's verdict is going to be by virtue of how fast they come back. Juries always have a tendency to make you look foolish when you try and predict what they're going to do. But that being said, a rapid verdict on this probably leans towards the state verdict.
It was interesting yesterday, Craig, the jury wanted to hear the testimony, or at least the transcript of the testimony, from two opposing expert witnesses. The defense's witness, who basically said, listen, this is a defendant who is brain damaged and mentally ill, had reduced capacity. They also then wanted to hear from the state's witness, who said just the opposite. No, he doesn't have fetal alcohol spectrum disorder. He actually has borderline personality disorder. He knew what he was doing. His motor skills were just fine. And in the end, they ended up just listening to the cross-examination of that defense witness, and then they said, we're good. We don't need to see any more of that. So to me, just as somebody who's been watching, not an attorney, not a legal expert, that also makes it seem like there were maybe some people in that jury who needed to be convinced of the perhaps majority view that the defendant had this borderline personality disorder and did have the mental capacity to know what he was doing.
Yeah, that could very well be. There could have been one or two jurors, at least the initial voting for life, and Dr. I believe his name was Dr. Connor. His testimony might have been sticking in their head, and they rehear it for whatever reason to try and solidify in their mind that they remembered it correctly. Because there was a lot to go through and a lot to remember. And when you're sitting back in there in the jury room trying to deliberate after hearing several months worth of testimony, thousands of documents admitted into evidence, it's a lot to keep track of. And so it didn't surprise me that they asked for a readback of something. That was a particularly interesting readback because said previously, while we've been going through this, Janine, that to a certain degree the mitigation and this part is going to come down to the battle of the experts, and that's exactly what it seemed to come down to, the battle between the defense experts and the state experts. And the jury wanted to hear a little bit more I presume, to make sure that their recollection of what they heard during trial was lined up with what their memory was.
And to you, what does it say that the jury wanted to see the murder weapon?
I don't know what to make of that. Usually they do want to see it, and because it's a big part of the case, and in this one, it's a big scary weapon. So the fact that they wanted to see it, probably leans towards a state verdict in this as well. It could also be that there were a couple of jurors who were leaning towards life, and those who were leaning death said, let's bring this gun in here and show it to you, so you can see what this was. That's entirely possible as well.
And not only the murder weapon and sort of how big and sort of allegedly scary it is, some of the thinking is that maybe the jurors wanted to see it because, according to this state expert, and you said, Craig, that sometimes this comes down to the battle of the experts, the state expert had testified that if you look at the surveillance video of Cruz going through the school, which we, the public, didn't see, but the juror saw, of course, that he was sort of very deft in his maneuvering of the gun and reloading it. And if there were some people who perhaps believed in the defense's argument that he had reduced fine motor skills and didn't quite have the mental capacity, how could he possibly work with a big, heavy semi-automatic rifle in the way that he did? So maybe they just wanted to sort of look at the actual weight and the size of that to think, well, you have to have a little bit of skill in order to operate one of these.
Yeah, that's entirely possible as well. Like, I apologize for hedging on this, but when you get 12 people in a room to talk about what they spent the last couple of months listening to and hearing about and reading about in the documentary evidence that was presented, sort of all bets are off of exactly how that dynamic works in that context. So they could have wanted to see that and read back Dr. Connor's cross-examination for a multitudes of reasons, all of which make perfect sense to the jury at the time. They don't necessarily make sense to us right now because we weren't in that dynamic. We weren't in there at that discussion trying to talk through what the heavy decision that they were charged with making.
It is an extremely heavy decision that they're charged with making, and it seems relatively quick that they came to a decision. So that either means that they're unanimous one way or another, unanimous for death, and or that maybe there were some people who just don't think that he should be put to death, and the decision was made because, listen, I'm not going to change my mind. I'm not going to go your way. Okay, we agree to disagree, and it's going to be life. That seems unlikely simply because this is now less than 24 hours after they got this case.
Right. Yeah. Well, that's entirely possible as well. I mean, there could be 2 or 3 or even just one juror who, when they, did their initial impressions of how they were going to vote, one could have said, I'm voting for life no matter what. You can show me the gun all you want. You can read back Dr. Connor's testimony, as far as I'm concerned, it's a life verdict. And they all collectively said, well, this is as far as we're going to go. We're not going to change that mind. And we're, 11-1 or this 5-7 or whatever the breakdown is. It's not unanimous, and there's no point in continuing on with this because if the mind's not going to be changed, that's entirely possible too, which would render it a life verdict.
Craig, tell me what's happening right now. So the jury has decided they've filled out their forms, they've signed their forms, they're going to make their announcement. So are they still sitting in the jury room discussing this, kind of knowing that they've made their decision and sitting with it until everybody gets into the courtroom? What's happening right now?
Yeah, they'll have filled out all 17 verdict forms properly as the judge instructed them to. So they're sitting there in the jury room. The forms are in the jury room. The jury's in the jury room. And whether they're talking about the case anymore, it's hard to say because we never get to see what happens in the jury room. But they'll be in that jury room just waiting to be called in to have the verdict read in open court. So they're just, they've been together for a long time. They've spent a lot of time waiting in that particular jury room during, sidebars that got lengthy and waiting for court to start in the morning when arguments were happening. So they're used to waiting with each other. But it's a little bit different now because their work is essentially done. So it's hard to say what they'll be talking about, but they will be in that room waiting with the 17 forms on the table.
And so,
or they might. No, I'm sorry. Go ahead.
And so they will then be brought in, and the judge will go through their forms, right, one by one, and the judge will then read each count, right? So count 1 is Luke Hoyer, count 2 is Martin Duque. That the judge reads through all of the counts, reads the verdict for each of the 17, and then she polls the jury, not to ask which way they voted, but to confirm that is the way that they voted, right? Like juror number 1, can you confirm that was your vote?
Right. Yeah, that usually only happens when there's a request to have the jury polled. Usually the clerk will, not the judge, but the clerk will read it. I don't know if you heard the Alex Jones verdict yesterday, but it was 20 minutes long of
yes.
The clerk reading every single verdict form as exactly as it was printed on the form. That's what will happen here. So they'll be hearing 17 different verdicts. It's going to take a bit of time. I imagine the judge is going to come out and say something like, look, we know we're reading the verdicts. I don't want any emotional outbursts either way on the verdicts. We need to keep this quiet in here, and there'll be a time for you to say your piece, but not while we're reading the verdict. That she's going to want to keep control over the courtroom because it could get, there are lots of emotions, very intense, bitter, raw emotions here. And depending on how the verdicts come out, 17 of them, it could be highly uncomfortable in that courtroom.
Absolutely. And Craig, I mean, we're looking at the gallery right now, and you can see some of these family members. We already saw the Dworettes wiping tears. This is an incredibly emotional time for everybody involved. But I think that you would agree with me, and you've been watching this every step of the way as well, that the family members have absolutely maintained composure every step of the way since day one. We really haven't seen any outbursts in the courtroom. And these jurors have also been praised for their diligence and for their patience. When you have attorneys on one side, 6 attorneys on one side and 6 attorneys on the other. I mean, there's lots of personalities in the courtroom. And so sometimes things happen behind the scenes. There are sidebars and the jury's waiting for a long time. The judge has really praised this jury for their diligence, for their work, for their patience. And it really just, I think it just shows that sure, you could argue the legal system isn't perfect, but it is a wonderful thing when everybody works together. Everybody in the community is working together.
Yeah, I mean, this case is ripe for frayed emotions and frayed nerves to have overboiled, and it just didn't happen, which is quite astounding. It wouldn't surprise me if it had. But I'm very pleased, and I have nothing but great things to say of everybody involved, from the defense table all the way through the prosecution table. I thought, very, very difficult case, very difficult circumstances for everybody involved, no matter how you're connected to this, that I think everybody handled it up to this point as professionally and diligently as they possibly could. And I've been saying this over and over with regard to the jury too, and I don't want to leave the jury out, because they did the heavy work in having to experience all this too, just out of the random luck that their names got drawn to come into jury service that particular day.
That's exactly right.
So they were going on their lives not thinking about this case, and then all of a sudden 3 months later they're making this life and death decision, and I would hope that the court would provide the jury with the possibility of getting some sort, talking to somebody, a professional, about the trauma that they've experienced reviewing this, and the trauma of making this heavy decision in either way, because I'm sure that that's going to stick with them a very long time. And I think that would be an enlightened thing at the end of this, all for the jury to have access to.
Craig Turchino with the University of Miami, thank you so much, as always, for your analysis. Eric, JC, we'll send it back to you as we wait for the verdict to be read.
All right, we appreciate that. It's very insightful to hear from Craig. It definitely is giving us somebody who's accustomed to these kind of court cases, especially capital cases, and knows what goes on in the courtroom between the jurors and the judge and everybody who is observing these last 3 months of testimony. Now, the interesting thing is, we thought we were getting a verdict at 10:15. We specifically were told it was being moved up from 10:30, but as you can see, that 10:15 time has come and gone. Now we are sitting at 10:25. So obviously the early announcement was not something that they could follow through with. So now we're just on standby, waiting for the judge to enter the courtroom, waiting for her to read that verdict that has been reached by the 12-member jury. So that is what we are doing right now, even as we have our reporters stationed inside the courtroom and outside the courtroom at the Broward County Courthouse.
You see there the faces, the emotion that today will bring. All those people on your screen right now and sitting in that part of the gallery, they sent loved ones to school 4.5 years ago on Valentine's Day, and 17 of them were killed. So many of these people on your screen have become community leaders and advocates and have demanded justice for the murder of their loved ones, and we are just minutes away from understanding what that will bring. Ian Margol has been covering this from the very beginning. He has spoken to many of these family members. Ian, so many of them have fought through the horrific testimony, relived one of the worst days of their lives to be there in the courtroom, many of them coming almost every single day. What has today meant for them? What has today been leading to in those family members you've spoken with over the last few years?
Sure, Eric. I think that for a lot of them, this is a beginning of an opportunity for closure, right? For a lot of these families, they will never, ever get over what happened years ago at Marjory Stoneman Douglas High School on Valentine's Day. But to get an answer and to begin to be able to move past this legal process, at least the criminal legal process, for a lot of them, this will be the beginning of a healing process. And it seems silly to say that that healing process maybe couldn't have started years ago, but for a lot of them, they've been waiting for this moment, the one we are expecting literally any minute now, for years and years. And as you mentioned, many of them have been here from beginning to end, some of them having to step out at some portions because it just got so unbelievably emotional for them. And we mentioned this morning that Lori Alhadeff had to step out yesterday during closings. And it did go relatively quickly after that. We were doing the math a little while ago, and it seems to be just about between 7 and 8 hours of deliberations for these jurors to come to their decision. We did hear initially 10:30, then we were being told 10:15. What I can tell you right now, the judge has yet to enter the courtroom. We are still waiting for Nikolas Cruz to enter the courtroom as well. And as soon as they do, as Craig Turchino mentioned, we will expect to hear from the judge to sort of ease into this process to say, okay, regardless of what the answers are for each of these 17 counts, let's stay quiet, let's stay calm, and they want to make sure that things stay collected in the courtroom we are expecting to hear, once this is all read and done with, we are expecting to get a statement from the prosecution. And then we are hoping to hear from some of those families. A lot of them have been, as we mentioned again before, hesitant to speak with the media. They were being told to sort of keep it quiet, wait until the end of all of this. We know that Nikolas Cruz now walking into the courtroom, and it does take a few minutes for him to get from downstairs here to the courtroom. So now, again, Nikolas Cruz entering the courtroom. We are just waiting for the judge to come in. The judge will then read the 17 counts, the decision the jury has made in all 17 counts on whether they have decided on life or death for each of those counts. And as we've reiterated several times this morning, those 17 counts, each one is an individual count. So they have to be unanimous for every single one for just the death penalty, for each one for the death penalty. So if there are several jurors for, again, count one for Luke Hoyer, several jurors say they want death penalties, some say they want life. That does not mean there's a hung jury. That just means they will be recommending life for that count. If they get a death penalty, that means that all of them have been unanimous on that count for the death penalty. That would be the recommendation they are making to the judge. So again, Nikolas Cruz entered the courtroom today just a few minutes ago, now speaking with his attorneys, waiting for the judge to enter, poll the jury, get their answers, get their recommendations before she then imposes a sentence on Nikolas Cruz. And Eric, to kind of go back to the question you were asking before, it will be then and only then for a lot of these families who we've gotten to know very, very well over the last few years, it'll be then and only then that they begin a healing process, a process of moving forward with their lives, because they have been stuck. While the world has continued moving on around them, a lot of them have been stuck on a day, on a year, several years back, on Valentine's Day, where they dropped their loved ones off at school and saw them go to school and not come back home. So we are waiting any moment now for that verdict to come in. As soon as the judge comes in, of course, we'll let you know. Eric, JC, I'll send it back to you for now.
None of us can imagine the grief that they have dealt with for all these years, the anger and the desperation for justice, and that's coming just minutes from now.
Okay, we are now at the 10:30 mark here on Local 10. For those of our viewers maybe just tuning in, we are on verdict watch right now. We originally were told that would happen at 10:30. It was moved up to 10:15. Now you can see we are waiting on the judge to enter the courtroom. Already we have the Parkland school shooter has taken his seat along with his defense team, the state. They are all sitting there, the prosecution, everybody is waiting. We have heard from our experts who've been covering this trial for 3 months now that this will be a little bit different than most capital cases. You will hear the verdict read by the judge herself, not the clerk in the courtroom. And we are watching these pictures in the gallery right now, the gallery of the courtroom, as you see the surviving victims who have been dealing with this, as Ian was just discussing, for so many years, trying to find justice for their loved ones, their husbands, their wives, their children. And now this is the day. Some can call it closure, some can call it the end to the legal battle at the very least, but you can see this is the moment so many people have been waiting for years now, and it looks like there's some rustling in the courtroom now. You're looking at the defense lawyers sitting right there with the Parkland school shooter, just waiting for the formality. When the judge walks into the courtroom, everybody is gathering. This is a verdict that was reached. We're hearing less than 24 hours after those closing arguments, and a total of 7 to 8 hours of 12 jurors in that one room discussing their thoughts, their opinions on the matter. And we do know the big discussion yesterday that we've heard about is the asking to see the AR-15. We found it so interesting as we talked to Craig, our legal expert, saying, well, why would they want to hold that gun and see that gun? But you can tell how seriously they were taking their decision in this process, that they wanted to know what that gun felt like, what it looked like, how it feels in your hands if you have that gun on that day and do what we know Nikolas Cruz has admitted to doing.
We have so much detail to get into here because as graphic and horrific as what happened that day are, there is so much nuance in what happens in the next few moments. There is so much to get into and explain and to understand about what the trial process and the sentencing trial process has been. We have had fantastic legal experts walking us through it. Janine Stanwood, she is still with us. Our continuing coverage as we await the verdict continues right now. Janine, I know you have another legal expert with you. We're so lucky to have these attorneys who have been there, maybe not in something to this magnitude, but Eric Schwartzreich is joining us now, criminal defense attorney. That was one thing that JC was asking, that we were asking, why would this jury want to look at the murder weapon? There's so many, we can't speculate, of course, but when you heard yesterday that they wanted to see that, especially towards the end of the day, what did that say to you?
So Janine's juror questions are windows or eyes into the soul of the jury. What it meant to me is that they've already made a determination. Have one of the 7 aggravators that Mike Satz and his team were trying to present proven beyond a reasonable doubt? Yes, because they would not have been at the mitigators, because if they didn't find an aggravator, it's game over. They don't get there. It means that they wanted to see, and I'm speculating here, reading the tea leaves, that this weapon was our swastika on it. Hatred, hatred is as the state said, is not a mental disorder. And the fine motor skills, because of this fetal alcohol syndrome that the defense has raised. What they want to know is, can they hold that weapon? How difficult it is to move, to plan, to calculate, to march with that weapon. So I think they wanted to see it. I think those questions have been answered, and I think that this is going to be a verdict that is death in how quick this jury was.
It's interesting because this jury, Eric, and you talked about them wanting to hold this weapon. They've already seen so much. They've already physically walked through that 1200 building. They saw autopsy photos, which we as the public did not see. I mean, thank God. I can't imagine, what this jury has seen, and the family members knowing what they have seen. And so for them to finally ask to hold that murder weapon, and perhaps you're right, maybe that dovetails with them wanting to hear the cross-examination of that defense witness who said, his fine motor skills may have been impaired, he had some mental issues, he's brain damaged. Maybe if he in fact were, it wouldn't be so easy to hold an AR, which is big and it's cumbersome, and to deftly move through hallways and reload it. How do you do that if you are as sort of low scoring as the defense had made him out to be?
So most lawyers will tell you that cases are won or lost in jury selection. In a case, a death case, it's 12 jurors, has to be unanimous. They just need one. So I think what happened here is that there was one juror, that the defense has done a masterful job. The fact that they were listening, and still, I don't know what the verdict's going to be, considering those mitigators, means that the defense found someone, picked someone on that jury that would listen. And it could be that there was someone back there that wanted to hold that rifle, that wanted to see it, and there were other jurors, because you get groupthink when you go back into a jury room. We think of that movie, 12 Angry Men, now there are 12 Angry Women. What's going on with these jurors? And there might have been one or two. There are different camps that were making arguments, and it could be, we're going to appease you. We're going to show you this rifle to show what's required for the motor skills to carry this, to hold this, also to see the swastika that was on there, which was an issue that the state and the defense had wrangled over. But I think the defense has done a masterful job. But I think when that rifle goes back there, I think upon the question they wanted to see, which was the cross-examination, Janine, remember, that's what they wanted to see, the cross of the defense doctor. It appears, and how quick this is, that this is going to be a death verdict.
If they wanted to listen to the cross-examination of the defense witness, they wanted to see how the state is poking holes in his argument?
I think they wanted to see, because Mike Satz did a very good job in that courtroom, as well as the defense. They wanted to see, his argument. Was he board certified? Did he know what he was talking about? Was he convincing? Did he somehow get shut down or refuted on this alcohol-related, this fetal alcohol syndrome?
And the answer is, as far as board certification goes, the answer is no. He was not. So we're looking right now, once again, Eric, at the gallery. You can see the Montaltos. You can see Alyssa Al-Hadaf's mom. You see Debbie and Chris Hickson's son, who gave a very powerful victim impact statement. This is something that so many people are watching. Looks like more of the defense team is coming in. And at this point, Eric, what are we waiting for? It sounds like the jury obviously is ready. The judge, I'm guessing, is getting herself ready too. There are a lot of moving parts when it comes to something like this. It's not unusual when they say, hey, verdict will be read at 10:30 and 8 minutes later it's not. That's not something that indicates anything or that's unusual.
It's not unusual, and this is not the case to make this analogy, but as a trial lawyer, this moment, it's like the Las Vegas moment or the casino, where while trial lawyers do what they do, there's a pit in your stomach and you're waiting and you're like, clerk, please get the verdict. The jurors, are they going to change their mind? Please go grab that verdict form. So that the state, the defense is on pins and needles, and in this case, the victim's family members too. What's going on in there is you can see the emotion on everyone, but there's logistics. I mean, is the deputy or the bailiff ready, or the BSO security, are they in place? I mean, do they have more arms up there, more armed guards coming up there when this verdict gets read? I imagine they're in place. We could be waiting for the judge. It's a logistics. They just need to go back in the jury room, grab those 17 verdicts. It's going to be given to the clerk, and the clerk will publish it. But this is the moment which lawyers wait for. I can feel it here, being in trial like over so many times, this moment, and in a death case. I mean, both sides and the family members. I mean, there's nothing worse or exciting. It's hard to say exciting in this case because there are no winners or losers here. This is an awful, heinous, atrocious case. The defendant pled to this case, and there just are going to be no winners here no matter what happens. But we all know this. The defendant in this case is going to come out of Florida State Prison in a pine box, whether it's on his own doing and natural causes, or someone takes out someone that's high profile, or if he picks his decision between an electric chair, or pick his poison, if you will, or lethal injection, if he gives up his appeals, if this is a death verdict, which I think it is, but nothing, you do this long enough, nothing is surprising.
Eric and JC, we have been talking about this for years. You were here, on the anchor desk. We all were. We were all working that day when this happened, February 14th, 2018. And to see it now after, so many years of advocacy and grief and changes and marches and divisions, and it's been something that has touched our community in a way that really little else has. And to get to this point in this courtroom where all of us are watching, and this is, I think there's something about local news, right? Because, we live in the community where this happens. So, we might run into parents or friends of victims at Publix. You never know who you're going to see. And so, Eric and JC, we have been talking about this for so long that now this is just a monumental time when we think that this decision is going to be made, and it's not going to change anything. It's not going to bring anyone back, but this is a moment that so many of us have been waiting for.
Especially because we covered the aftermath of the loss in our community, and then we covered the marches to make changes to gun ownership and gun laws, not only here at the state level, but also federally. We covered these students going to DC. And then also we watched as these leaders, these victims who've lost their family members became leaders in our community. I mean, so many of us have children that now have school board members that became school board members expressly because of what happened on that day 4 years ago, that were never actively involved in the school board, but are now to make changes in South Florida schools and security, and how we take care of our children, and how we do active shooter drills, and how we will be better prepared for the next time, God forbid, something like this ever happens again. But above and beyond that, even if you do not know somebody who suffered at Marjory Stoneman Douglas on Valentine's Day, you can't tell me that there's not a person here in South Florida that celebrates Valentine's Day without thinking about these people that we all lost, these students, these children, these parents, these educators, these coaches, all of us. Even as you want to have that heart on Valentine's Day for the ones you love, your mind does not pass up we lost those beautiful people, all of us. Every single one of us in South Florida lost those beautiful people for no reason. And watching this trial for 3 months shows you that there was no reason for it to happen. And our hearts are on the line, and we're looking for an end to the legal battle. But the closure, I mean, does South Florida ever have closure, or does South Florida now have activists and people who are forever changed because of that day?
We certainly will have a portion of both. The weight of what happened that day is something that impacts every single member of this community. The faces we see certainly on the screen now, the faces of the families of those victims, they're familiar, but it's heartbreaking for the reason why. You know, we have seen them and spoken with them so many times over the course of the last 4.5 years or so. In the initial stages, just trying to process the depth of their grief, and then in their advocacy, in all ways, pursuing memories and legacies and making sure that their loved ones are never forgotten, and also pursuing improvements in our community, in our school security, in the way that we set up our education plan, in our response, in our training, in all ways, trying to make sure that what happened to them, that the horror that they are living through does not, or they would attempt to make sure that it does not ever happen again in communities here in South Florida or really all across the country. And so for them to know what they've been weighing and what they've been living through, and hearing them tell us, because through that grief and through that heartbreak, they have been vocal, and they have been open, and they have been willing to discuss, and they have begged us to keep their family members' memories alive because of the importance of what this next few moments will mean, and the importance of their family members' lives. Look, we see the pictures of these young teenagers, and of course of those young educators and of these school administrators. These are the lives and the loves behind those, and it looks like there was some reaction there in the courtroom. We may have some developing activity, as it looked like every single member of the gallery in the family section turned and looked towards where the judge would sit. Maybe it was just a momentary happening right there. But it's heavy. This is a heavy moment because of the depth of what we've all tried to work through the last few years. And certainly in every single situation, in every single moment, had each one of those victims' family members in our hearts in every aspect of our coverage.
And I think, Eric, that's a really good point about everybody's individual advocacy, because not every Parkland family member or loved one or people who have been affected by this wanted certain gun safety measures. Some said that the issue was with the Broward County school system, but indeed everybody has unfortunately been now part of this club that they'd never want to be a part of, that their loved ones have been killed. And so to see them together and to see these family members, the ones who are in the gallery, many of them have, at the end of each day, they have embraced, they have hugged each other, they have tried to shake hands with the state team. And so, and you can see right there, that's Scott Beagle. That is Scott on the phone I'm guessing that's Linda Schulman looking at her phone, reminding her and reminding us. And I'm really glad that we have this picture up, because that's what it's all about.
Look, I mean, just every second, every moment that screen times out, touches it again, looking at his face over and over and over again.
Wow.
It's powerful.
That is very powerful, very emotional for all of us, as she's waiting to find out what this jury has decided in this verdict. I know it's going to be some time as we wait for the judge to arrive, to leave her chambers and approach that courtroom. But it's interesting, if people are watching right now, I know, Janine, you're there with Eric. Some people might have the question as to why the trial took place when there was some divisiveness, obviously, over whether the Parkland school shooter should receive the death penalty or whether he should receive life in prison without the possibility of parole. So for those who do ask that question, who maybe don't know the ins and outs of the legal system and why we had this trial, dragging these emotions, dragging these family members and these victims and these survivors through exactly the horrific moments that we all lived through in 2018. But the reason is because this wasn't something that everybody agreed on in terms of the school shooter's punishment, even though we know what his wishes were and we know what some of those family members' wishes were. This is why we had to go through the entire trial, to actually see it through beginning to end in terms of justice, even though that must have been the hardest thing for every single one of those people to do, reliving every moment all over again 4.5 years later.
Well, this is the penalty phase. So he pleaded guilty, Eric, to 17 counts of murder, 17 counts of attempted murder, but there was no plea deal. And the state said, listen, if there's ever going to be a death penalty case, it's this one. So the state pursued it, and that's why we have this. This isn't guilt or innocence, but in a way, this was almost a mini trial, taking everyone back through the facts of what happened.
Right, and you don't often see this. It isn't guilt or innocence. It is about death or life, and it was the defendant in this case that made that decision on behalf, with the advice of his lawyers, to take this plea. And yes, the state did not agree, because they weren't going to agree in this case to waive death, because if you have the death penalty in the state of Florida, no matter what your feelings are for the death penalty, certainly this is a case, I don't think anyone can think of anything more heinous or worse than facts like this to support the death penalty if you believe in the death penalty. So it was also a calculated decision to plea the liability, and Mr. Cruz had to accept that, because the defense said, you know what, they've got him, there's video, there's his confession with Detective Curcio that was done, there were his videos that he posted, and all this overwhelming evidence. I mean, he posted on social media that he wanted to be the next school shooter, so the defense figured, no, emergency surgery, we have to try and save the defendant's life in this case. So that's why this decision was made. And yes, but the victims and, had to go through, and whether there was a change of venue in this case, which I think was alluded to, which is a different issue. I see that the jury, I think, is coming in, or the judge is about to come in.
Yep, let's take a listen inside the courtroom.
Okay, court is back in session. The lawyers are present. The defendant is present. It is my understanding that the jurors have reached a verdict in this case. Are both sides ready to bring in the jurors?
State's ready, Your Honor.
Defense?
Defense is ready, Your Honor.
Okay.
Jurors are entering. All jurors are present.
Okay, the jurors are present. Everyone else may be seated. Ladies and gentlemen, it's my understanding that you have reached a verdict in this case. Mr. Thomas, you're the foreperson?
Yes, ma'am.
Would you please pass the verdict forms to the bailiff? All right, all of the verdict forms have been properly executed and dated and signed by the foreperson. At this time, I'm going to publish the verdicts. The State of Florida versus Nikolas Cruz, verdict form as to count 1. We, the jury, find as follows as to Nikolas Cruz in this case. Aggravating factors as to count 1, victim Luke Hoyer. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. Nikolas Cruz was previously convicted of another capital felony or felony involving the use or threat of violence to another person. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. Nikolas Cruz created a great risk of death to many persons. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. The first-degree murder of Luke Hoyer was committed while Nikolas Cruz was engaged in the commission of a burglary. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. The first-degree murder of Luke Hoyer was especially heinous, atrocious, or cruel. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. The first-degree murder of Luke Hoyer was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes. Reviewing the aggravating factors that we unanimously found to be established beyond a reasonable doubt, we, the jury, unanimously find that the aggravating factors are sufficient to warrant a possible death sentence. Yes. One or more individual jurors find that one or more mitigating circumstances was established by the greater weight of the evidence. Yes. We, the jury, unanimously find that the aggravating factors that were proven beyond a reasonable doubt outweigh the mitigating circumstances. No. Signed October 13th by the foreperson. Mr. Benjamin. Verdict form as to count 2, victim Martin Duque. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. Nikolas Cruz was previously convicted of another capital felony or felony involving the use or threat of violence to another person. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. Nikolas Cruz knowingly created a great risk of death to many persons. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. The first-degree murder of Martin Duque Anquiano was committed while Nikolas Cruz was engaged in the commission of a burglary. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. The first-degree murder of Martin Duque Anquiano was especially heinous, atrocious, or cruel. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. The first-degree murder of Martin Duque Anquiano was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes. Reviewing the aggravating factors that we unanimously found to be established beyond a reasonable doubt, we, the jury, unanimously find that the aggravating factors are sufficient to warrant a possible sentence of death. Yes. One or more individual jurors find that one or more mitigating circumstances was established by the greater weight of the evidence. Yes. We, the jury, unanimously find that the aggravating factors that were proven beyond a reasonable doubt outweigh the mitigating circumstances established as to count 2, Martin, Duque, and Quiano. No. Signed and dated by the foreperson, Mr. Benjamin Thomas. Count 3, Gina Montalto. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. Nikolas Cruz was previously convicted of another felony, capital felony, or of a felony involving the use of threat of violence to another person. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. Nikolas Cruz knowingly created a great risk of death to many persons. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. The first-degree murder of Gina Montalto was committed while Nikolas Cruz was engaged in the commission of a burglary. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor that the first-degree murder of Gina Montalto was especially heinous, atrocious, or cruel. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. The first-degree murder of Gina Montalto was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes. Reviewing the aggravating factors that we unanimously found to be established beyond a reasonable doubt, we, the jury, unanimously find that the aggravating factors are sufficient to warrant a possible sentence of death. Yes. One or more individual jurors find that one or more mitigating circumstances was established by the greater weight of the evidence. Yes. We, the jury, unanimously find that the aggravating factors that were proven beyond a reasonable doubt outweigh the mitigating circumstances established. No. Signed and dated by the foreperson, Mr. Benjamin Thomas. Count 4, Alexander Schachter. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. Nikolas Cruz was previously convicted of another capital felony or of a felony involving the use or threat of violence to another person. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. Nikolas Cruz created a great risk of death to many persons. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor that the first-degree murder of Alexander Schachter was committed while Nikolas Cruz was engaged in the commission of a burglary. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor that the first-degree murder of Alexander Schachter was especially heinous, atrocious, or cruel. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor the first-degree murder of Alexander Schachter was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification? Yes. Eligibility for the death penalty. We, the jury, unanimously find that the aggravating factors that were proven beyond a reasonable doubt outweigh the mitigating circumstances established as to count 4. No. Signed and dated October 13th, foreperson, Benjamin Thomas. Verdict form as to count 5. Elena Petty. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor Nikolas Cruz was previously convicted of another capital felony or of a felony involving the use or threat of violence to another person. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor Nikolas Cruz knowingly created a great risk of death to many persons. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. The first-degree murder of Elena Petty was committed while Nikolas Cruz was engaged in the commission of a burglary. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. The first-degree murder of Elena Petty was especially heinous, atrocious, or cruel. Yes. We, the jury, unanimously find that the state has proven beyond the reasonable doubt the existence of the aggravating factor that the first-degree murder of Elena Petty was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes. Reviewing the aggravating factors that we unanimously found to be established beyond a reasonable doubt, we, the jury, unanimously find that the aggravating factors are sufficient to warrant a possible sentence of death. Yes. One or more individual jurors finds that one or more mitigating circumstances was established by the greater weight of the evidence. Yes. Eligibility for the death penalty as to Elena Petty. We, the jury, unanimously find that the aggravating factors that were proven beyond a reasonable doubt outweigh the mitigating circumstances established. No. Signed and dated October 13th by the foreperson, Mr. Benjamin Thomas. Count 6, victim Alyssa Al-Hadef. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor Nikolas Cruz was previously convicted of another capital felony or of a felony involving the use or threat of violence to another person. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor Nikolas Cruz knowingly created a great risk of death to many persons. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor that the first-degree murder of Alyssa Al-Hadef was committed while Nikolas Cruz was engaged in the commission of a burglary. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor the first-degree murder of Alyssa Al-Hadef was especially heinous, atrocious, or cruel. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor the first-degree murder of Alyssa Al-Hadef was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes. Reviewing the aggravating factors that we unanimously found to be established beyond the reasonable doubt, We, the jury, unanimously find that the aggravating factors are sufficient to warrant a possible sentence of death. Yes. One or more individual jurors finds that one or more mitigating circumstances was established by the greater weight of the evidence. Yes. We, the jury, unanimously find that the aggravating factors that were proven beyond a reasonable doubt outweigh the mitigating circumstances established. As to Alyssa Al-Hadef, no. Signed and dated October 13th by the foreperson Benjamin Thomas. Count 7, Nikolas Cruz. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. Nikolas Cruz was previously convicted of another capital felony or of a felony involving the use or threat of violence to another person. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. Nikolas Cruz knowingly created a great risk of death to many persons. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor that the first-degree murder of Nikolas Cruz was committed while Nikolas Cruz was engaged in the commission of a burglary. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor that the first-degree murder of Nikolas Cruz was especially heinous, atrocious, or cruel. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor the first-degree murder of Nikolas Cruz was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes. Reviewing the aggravating factors that we unanimously found to be established beyond a reasonable doubt, we, the jury, unanimously find that the aggravating factors are sufficient to warrant a possible sentence of death. Yes. One or more individual jurors find that one or more mitigating circumstances was established by the greater weight of the evidence. Yes. Eligibility for the death penalty as to Nikolas Cruz. We, the jury, unanimously find that the aggravating factors that were proven beyond a reasonable doubt outweigh the mitigating circumstances established. No. Signed, October 13th, foreperson Benjamin Thomas. Verdict form as to count 8, Helena Ramsey. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. Nikolas Cruz was previously convicted of another capital felony or of a felony involving the use or threat of violence to another person. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. Nikolas Cruz knowingly created a great risk of death to many persons. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. The first-degree murder of Helena Ramsey was committed while Nikolas Cruz was engaged in the commission of a burglary. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor that the first-degree murder of Helena Ramsey was especially heinous, atrocious, or cruel. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. The first-degree murder of Helena Ramsey was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes. Reviewing the aggravating factors that we unanimously found to be established beyond a reasonable doubt, we, the jury, unanimously find that the aggravating factors are sufficient to warrant a possible sentence of death. Yes. One or more individual jurors find that one or more mitigating circumstances was established by the greater weight of the evidence. Yes. Eligibility for the death penalty as to Helena Ramsey. We, the jury, unanimously find that the aggravating factors that were proven beyond a reasonable doubt outweigh the mitigating circumstances established. No. Signed and dated October 13th, 2022 by foreperson Benjamin Thomas. Aggravating factors as to verdict form as to count 9, victim Christopher Hickson. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. Nikolas Cruz was previously convicted of another capital felony or of a felony involving the use or threat of violence to another person. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. Nikolas Cruz created a great risk of death to many persons. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor that the first-degree murder of Christopher Hickson was committed while Nikolas Cruz was engaged in the commission of a burglary. Yes. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor, the first-degree murder of Christopher Hickson, was especially heinous, atrocious, or cruel. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor that the first-degree murder of Christopher Hickson was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. The first-degree murder of Christopher Hickson was committed to disrupt or hinder the lawful exercise of any governmental function or the enforcement of the laws. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. Christopher Hickson was an appointed public official engaged in the performance of his official duties. If the motive for the first-degree murder was related in whole or in part to Christopher Hickson's official capacity. Yes. Reviewing the aggravating factors that we unanimously found to be established beyond a reasonable doubt, we, the jury, unanimously find that the aggravating factors are sufficient to warrant a possible sentence of death. Yes. One or more individual jurors find that one or more mitigating circumstances was established by the greater weight of the evidence. Yes. We, the jury, unanimously find that the aggravating factors that were proven beyond a reasonable doubt outweigh the mitigating circumstances. No. Signed and dated October 13th, foreperson Benjamin Thomas. Verdict as to count 10, Carmen Schentrup. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor that Nikolas Cruz was previously convicted of another capital felony or of a felony involving the use or threat of violence to another person. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor Nikolas Cruz knowingly created a great risk of death to many persons. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor that the first-degree murder of Carmen Schentrup was committed while Nikolas Cruz was engaged in the commission of a burglary. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor the first-degree murder of Carmen Schentrup was especially heinous, atrocious, or cruel. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor the first-degree murder of Carmen Schentrup was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes. Reviewing the aggravating factors that we unanimously found to be established beyond a reasonable doubt, we, the jury, unanimously find that the aggravating factors are sufficient to warrant a possible sentence of death. Yes. One or more individual jurors find that one or more mitigating circumstances was established by the greater weight of the evidence. Yes. Eligibility for the death penalty as to victim Carmen Schentrup. We, the jury, unanimously find that the aggravating factors that were proven beyond a reasonable doubt outweigh the mitigating circumstances established. No. Signed October 13th, foreperson Benjamin Thomas. Count 11, Aaron Feist, victim Aaron Feist. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor Nikolas Cruz was previously convicted of another capital felony or of a felony involving the use or threat of violence to another person. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor Nikolas Cruz created a great risk of death to many persons. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor that the first-degree murder of Aaron Feist was committed while Nikolas Cruz was engaged in the commission of a burglary. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor the first-degree murder of Aaron Feist was especially heinous, atrocious, or cruel. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor that the first-degree murder of Aaron Feist was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor, the first-degree murder of Aaron Feist was committed to disrupt or hinder the lawful exercise of any governmental function or the enforcement of laws. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. Aaron Feist was an appointed public official engaged in the performance of his official duties if the motive for first-degree murder was related in whole or in part to Aaron Feist's official capacity. Yes. Reviewing the aggravating factors that we unanimously found to be established beyond a reasonable doubt, we, the jury, unanimously find that the aggravating factors are sufficient to warrant a possible sentence of death. Yes. One or more individual jurors finds that one or more mitigating circumstances was established by the greater weight of the evidence. Yes. Eligibility for the death penalty as to count 11, Aaron Feist. We, the jury, unanimously find that the aggravating factors that were proven beyond a reasonable doubt outweigh the mitigating circumstances established. No. Signed this 13th day of October, foreperson Benjamin Thomas. Verdict as to count 11, victim Scott Beagle. We, the jury, unanimously find that the state has proven beyond a reasonable doubt the existence of the aggravating factor. Nikolas Cruz was previously convicted of another capital felony or of a felony involving the use or threat of violence to another person. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. Nikolas Cruz knowingly created a great risk of death to many persons. Yes. We, the jury, unanimously find the state has established beyond a reasonable doubt the existence of the aggravating factor. The first-degree murder of Scott Beagle was committed while Nikolas Cruz was engaged in the commission of a burglary. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. The first-degree murder of Scott Beagle was especially heinous, atrocious, or cruel. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. The first-degree murder of Scott Beagle was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. The first-degree murder of Scott Beagle was committed to disrupt or hinder the lawful exercise of any government function or the enforcement of laws. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. Scott Beagle was an appointed public official engaged in the performance of his official duties. If the first-degree murder was related in whole or in part to Scott Beagle's official capacity. Yes. Reviewing the aggravating factors that we unanimously found to be established beyond a reasonable doubt, we, the jury, unanimously find that the aggravating factors are sufficient to warrant a possible sentence of death. Yes. one or more individual jurors find that one or more mitigating circumstances was established by the greater weight of the evidence? Yes. Eligibility for the death penalty as to count 12, victim Scott Beagle. We, the jury, unanimously find that the aggravating factors that were proven beyond a reasonable doubt outweigh the mitigating circumstances established. No. Signed October 13th, foreperson, Benjamin Thomas. Verdict form as to count 13, Meadow Pollock. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor that Nikolas Cruz was previously convicted of another capital felony or a felony involving the use or threat of violence to another person. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor Nikolas Cruz knowingly created a great risk of death to many persons. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor the first-degree murder of Meadow Pollock was committed while Nikolas Cruz was engaged in the commission of a burglary. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor that the first-degree murder of Meadow Pollock was especially heinous, atrocious, or cruel. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor the first-degree murder of Meadow Pollock was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes. Reviewing the aggravating factors that we unanimously found to be established beyond a reasonable doubt, we, the jury, unanimously find that the aggravating factors are sufficient to warrant a possible sentence of death. Yes. Shh. One or more individual jurors find that one or more mitigating circumstances was established by the greater weight of the evidence. Yes. We, the jury, unanimously find that the aggravating factors that were proven beyond a reasonable doubt outweigh the mitigating circumstances established as to Meadow Pollock. No. Signed October 13th, foreperson, Benjamin Thomas. Jury verdict form as to victim Kara Loughran. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. Nikolas Cruz was previously convicted of another capital felony or of a felony involving the use or threat of violence to another person. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor Nikolas Cruz knowingly created a great risk of death to many persons. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor that the first-degree murder of Kara Loughran was committed while Nikolas Cruz was engaged in the commission of a burglary. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor the first-degree murder of Kara Loughran was especially heinous, atrocious, or cruel. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor, the first-degree murder of Kara Loughran was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes. Reviewing the aggravating factors that we unanimously found to be established beyond a reasonable doubt, we, the jury, unanimously find that the aggravating factors are sufficient to warrant a possible sentence of death. Yes. One or more individual jurors finds that one or more mitigating circumstances was established by the greater weight of the evidence. Yes. Eligibility for the death penalty as to victim Kara Loughran. We, the jury, unanimously find that the aggravating factors that were proven beyond a reasonable doubt outweigh the mitigating circumstances established as to Kara Loughran. No. Signed, Benjamin Thomas, October 13th, 2022. Count 15, victim Joaquin Oliver. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. Nikolas Cruz was previously convicted of another capital felony or of a felony involving the use or threat of violence to another person. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. Nikolas Cruz knowingly created a great risk of death to many persons. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor that the first-degree murder of Joaquin Oliver was committed while Nikolas Cruz was engaged in the commission of a burglary. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. The first-degree murder of Joaquin Oliver was especially heinous, atrocious, or cruel. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. The first-degree murder of Joaquin Oliver was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes. Reviewing the aggravating factors that we unanimously found to be established beyond a reasonable doubt, we, the jury, unanimously find that the aggravating factors are sufficient to warrant a possible death sentence. Yes. One or more individual jurors find that one or more mitigating circumstances was established by the greater weight of the evidence. Yes. Eligibility for the death penalty as to victim Joaquin Oliver. We, the jury, unanimously find that the aggravating factors that were proven beyond a reasonable doubt outweigh the mitigating circumstances established. No. Dated October 13th, foreperson Benjamin Thomas. Verdict form as to count 16, victim Jamie Gutenberg. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. Nikolas Cruz was previously convicted of another capital felony or of a felony involving the use or threat of violence to another person. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. Nikolas Cruz knowingly created a great risk of death to many persons.
Frozen. So right now, as we're watching this, as we're watching the judge read the verdict from the jury, there is just a little technical issue right now. The feed is frozen. That sometimes happens with live television, so do bear with us. But so far, Eric, we've gone through all 15, now 16 counts, and although the jury has found that the state has met the aggravators, they could not agree that they outweigh the mitigating circumstances. So far, life for the defendant.
That's right, Janine, and it's not over yet because we have 2 more counts and 2 more victims there. But it looks like, and what happened is that the jury found all of the aggravators. Every aggravator existed. They found the existence of the mitigators, the mental health, and they don't feel that the aggravators outweigh the mitigators, and it looks like it is going to be life for the defendant in this case.
And so at least one person on the jury felt this way, and because of that, because it has to be unanimous, it is life. And once we get done with all 17, the judge at this point, under Florida law, can't upgrade it. She can't say, well, I disagree, because this is just a recommendation to the judge.
It's over. It used to be in Florida that if a jury made a recommendation of life, a judge can look at it and overrule that, but no more. It is game over. And if the jury's ultimate recommendation...
For the death penalty,
all right, we're back.
as
Let's
to
listen.
Jamie Gutenberg. We, the jury, unanimously find that the aggravating factors that were proven beyond a reasonable doubt outweigh the mitigating circumstances established. As to Jamie Gutenberg, no. Signed, Benjamin Thomas, October 13th, 2022. Count 17, Peter Wang. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. Nikolas Cruz was previously convicted of another capital felony or of a felony involving the use or threat of violence to another person. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. Nikolas Cruz knowingly created a great risk of death to many persons. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. The first-degree murder of Peter Wang was committed while Nikolas Cruz was engaged in the commission of a burglary. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. The first-degree murder of Peter Wang was especially heinous, atrocious, or cruel. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. The first-degree murder of Peter Wang was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes. Reviewing the aggravating factors that we unanimously found to be established beyond a reasonable doubt, we, the jury, unanimously find that the aggravating factors are sufficient to warrant a possible sentence of death. Yes. One or more individual jurors find that one or more mitigating circumstances was established by the greater weight of the evidence. Yes. Eligibility for the death penalty as to Peter Wang. We, the jury, unanimously find that the aggravating factors that were proven beyond a reasonable doubt outweigh the mitigating circumstances established as to count 17, Peter Wang. No. October 13th, 2022, signed by foreperson Benjamin Thomas. Madam Clerk, would you please poll the jurors?
Mr. Thomas, is this your verdict?
Yes.
Tony De Vega, is this your verdict?
Yes.
Stephen Crock, is this your verdict?
Yes.
Janine Benbow, is this your verdict?
Yes.
Andrew Johnson. Annette Sanchez, is this your verdict?
Yes.
Stacy Lezing, Jim, is this your verdict?
Yes.
Melody Van O, is this your verdict?
Yes.
Mirel Rinkus, is this your verdict?
Yes.
Dimitri Bahara, is this your verdict?
Yes.
Gabriel Figueroa, is this your verdict?
Yes.
And Denise, is it Convo? Is this your verdict?
Yes.
Thank you.
Members of the jury, I wish to thank you for your time and consideration in this case. I also wish to advise you of the following. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. Your deliberations, discussions, and votes should remain your private affair if that's what you wish. Therefore, the law gives you the privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you're also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. At this time, the sheriff's office is going to escort the jurors out of the courtroom. Okay, the defendant, having previously been adjudicated of 17 counts of murder in the first degree, the jury having returned a verdict of life imprisonment without the possibility of parole. Is there any legal reason why I should not impose a sentence at this time?
Yes, Your Honor.
Okay.
And that is under 921.143, the victims under counts 1 through 17, and also the surviving victims of the attempted homicides have a right to express themselves as to the everything that could not be expressed under victim impact. They can express themselves as to crime and what they think should have been the appropriate disposition and sentence. It is anticipated that that could be a lengthy sentencing hearing because it applies to all 34 counts of the indictment.
Okay, are you prepared to present that testimony now?
No, we're not, Your Honor. And under the statute, it says that the victims have a right to present that testimony, and also, as you know, under the Florida Constitution, the victims have a right to be heard, and that the victim should present that testimony before you announce sentence.
Okay, when can we do that on November 1st, which is a Tuesday?
Yes, Your Honor.
Okay, I'll reset the sentencing for November 1st, Tuesday at 9 a.m. So the defendant will remain in the custody of the Broward Sheriff's Office until such time as he's sentenced.
Thank you, Your Honor.
Is there anything else for today?
Nothing from the defense, Your Honor.
Okay, thank you. We're in recess.
And the jury has come back. The announcement now official. The recommendation of life in prison for each of the 17 counts against the Parkland school shooter.
You were just listening to the judge read out every single victim's name, and then she went through all the details that we've been discussing in great detail with you. And I know we have Janine with Eric, who's our legal expert. And for those at home, there was a lot of confusion as she was reading out those counts. People at home were thinking that the Parkland school shooter was sentenced to death, but that in fact was not the case, because every single time she read those counts, the last thing she read when she was comparing the cases of what was to be held, the mitigating circumstances, and the answer was always no, the mitigating circumstances. And so if you could explain to us right now what that means for those watching at home, because there was definitely people thinking that he was going to receive the death penalty, and that was not the case, not for one of the 17 counts.
No, I think there was a little bit of confusion at first, and I think it just might have been the way she was reading those jury instructions. But Eric, she basically established that the jurors in each count said, yes, the state has met all of those aggravating factors. However, not all of the jurors believed that they outweighed the mitigating circumstances.
That's correct. So what happened is the state was presenting 7 aggravators. This jury found beyond a reasonable doubt, which was the state of Florida's burden of proof, that each and every one of those aggravators existed, that this was cruel, atrocious, heinous, that this was committed during the course of a burglary, it was done to disrupt a school function. All of those aggravators. They just needed to find one, but the jury did find all of those aggravators existed. Then they went on to the mitigation, and they found that there was the defense, the fetal alcohol related syndrome, was valid in their minds. And in the last question, and yes, it got confusing with the way it was on the verdict and the way the judge read it, but it was that last question which says that we do not find that these mitigators are outweighed by the aggravators, that the aggravators do not outweigh the mitigators, and because of that, it is life. It just took one juror here. I think a lot of people are probably shocked with this verdict, because if you're going to have the death penalty, this is the case. I mean, I can't think of another case, but you have to, what the defense did in this case, I mean, in the jury selection and picking those jurors, I mean, really need to be commended for, in a case like this where 17 people were murdered and school children, and that it was not a death penalty case is really, really amazing, and that's kudos to the work of the defense.
And speaking of the defense, if you're looking on the other side of your screen, you can see that's the defense team right there. They're wiping away tears. Family members have been embracing and also wiping away tears for a different reason. Many, if not most, have said publicly that they do want the death penalty. They thought that was appropriate, not that it would bring back their loved ones, but to them it was a sense of justice. Craig Tricino, I think we also have him over Zoom. We're so lucky to have both of these attorneys here who are doing some legal analysis for us. Craig, it wasn't always this way, that you needed to have a unanimous decision for death, right?
No, that's correct. It used to be a majority rule on the recommendation. So 7-5 for death would have done it. But in 2016, the United States Supreme Court, in a case called Hurst versus Florida, held that scheme unconstitutional and required the unanimity that we now have.
Were you surprised by this? You have also been watching this every step of the way. What did you think, especially considering that it really only took them 7 to 8 hours of deliberation time?
Yeah, I was a little bit surprised, not 100% completely caught off guard by it. I thought that, I agree with Eric that the defense did a terrific job. I thought, and I've said while I was in studio with you previously, Janine, that I thought the state went a little bit too far in certain circumstances. I didn't think they needed to go to the school. I didn't think they needed to do a lot of things. I didn't think they needed to present the swastikas and all that stuff. I think it's very possible for the prosecution to overtry a case. I fear that's probably what happened here. It took a long time for the jury to be exposed to all this stuff, and we don't know if it's one juror holdout. We don't know if it was 5 to 7, 5 people holding out. All we know that it wasn't unanimous, and that it needed to be unanimous. So I think that I'd like to bring the focus back to a certain degree on the jury and the Herculean effort that they were charged with doing, and that they had to do it 17 times, and they appeared to be paying terrific attention throughout the entire trial, throughout the entire process. They took it very, very serious, as they should, and they did, and they rendered this verdict that they rendered. And in our American judicial system, we have to respect the jury's verdict. There's no other way around it.
Craig, thank you so much. Eric, the question is, all of this happened very quickly. So the question is, when this happens, when you're in the jury room, if there are those who say, okay, most of us want death, but here are some holdouts, do you try to work that out and convince them? Or are these previously held convictions, and no matter what, the holdouts convince the others, listen, there's nothing you can do to change my mind. Let's just read the verdict. How does that work?
You know, Janine, I go back to the movie or the book we're all familiar with, 12 Angry Men, 12 Angry Women. You know, and it was a short deliberation for a case that took at least 30 days of trial testimony. And it was maybe 24 hours. So these jurors had to, and I'm speculating here because, you know, again, we're speculating, it probably was more than one, that they were in camps because it didn't seem like there was much of a fight put on. The foreperson, and I'm not sure if that foreperson agreed with the verdict, but if he didn't, he signed the verdict. There was that jury question, Janine, where they wanted the cross-examination of the defense witness. They wanted the rifle brought in there. It might have been done to appease a juror or a camp, but it didn't seem like there was much fight going on. Maybe some of the jurors said, as you and I have talked about, Janine, you're not going to convince me. I'm standing my ground here. There's nothing that you're going to be able to do. But it seemed like such a quick verdict. It only took one. I imagine they were in camps and there was fighting. Even when the jury was polled, you could hear the, yeah, is this your verdict? Yeah, yes. You heard one juror sad, but what everyone's going on in that courtroom.
Some of them, you absolutely heard them through tears. I believe we have our Christina Vasquez. She's been through this every step of the way, even beginning with jury selection. Christina, please take us through what happened in court today.
And jury selection is a great place to start because remember, as you take this all in, that these were all folks who told this court they could be fair and impartial when it came to sentencing. Specifically, what that means in a penalty phase is that they could put any personal beliefs or biases aside to carefully weigh and consider the evidence in this case. And it's interesting to hear Craig Trocino talk and wonder aloud about whether there are perhaps camps within that jury box today. So I can tell you it was astonishing, absolutely striking to see the difference in body language in that jury box. So as soon as that 12-member jury walked in, there was a group of 5 that went right to the back pew. The rest were in the front pew. So instant division in terms of where they decided, right, to self-select to seat. And before anything had even got underway, we had one juror in that front row. She told the court she's a legal assistant. She's already beginning to tear up. But there's these 2 young men in that front row. One's a probation officer, the other one is a retail stocking supervisor. They are literally physically huddled over on themselves. In fact, one was down so low that his head didn't clear the front wooden panel of that jury box. And during the course, as the judge begins to read through their recommendation, they looked anguished. I mean, heads on hands, one of them just kind of with their hands pressed together and up against their nose and huddled over. And as that's happening, there is an older female juror in the back. We know that she's a library worker, and she seems so calm. I mean, she is stretching her back at a certain point. She took a sip from an insulated coffee mug. She did look over at the family members, but with ease. So you have these 2 young men in the front that can't even keep not only their heads up, they can't even keep their upper body up. They are just recoiled in what looks like pain and anguish, and they look visibly pained. And the contrast with at least one juror in the back who looks quite comfortable. The juror to her right, she's a compliance officer for a medical device company. She had her head a little bit hung low, and then as it continues to march through that very methodical and for, I'm sure, the family members of the murdered, quite painful experience, as the realization is coming that for some of them, this may not have been the outcome that they were anticipating. You have another female juror in the front row that begins to tear up. I'm sure you saw it on the live feed that we've been bringing you, but you do have the family members going through count by count by count, a difficult process for them. 17 Marjorie Stoneman Douglas staff and students murdered. And as that process goes through, each collective family member goes through their own moment, right, where they have their moment of recognition of what the outcome is and what this jury has recommended as the punishment in this case. And they begin to, you might have seen, and I don't know if you saw in the live feed, but you have Fred Guttenberg, he's holding hands with his wife. By the time we got to the count for his daughter, Jamie, the Scott Beagle's family actually turns and kind of holds his hand, almost like, okay, well, maybe on this one, because you have to remember, for some of the family members of the murdered, they have been stated in the public in the past that they had desired to see a jury recommend death as the appropriate punishment here, but that did not happen today. And you have to consider that when you were hearing the judge go through those verdict forms, remember, they first had to find that the state, that an aggravating factor, heinous, atrocious, or cruel, cold, calculated, premeditated, that they existed, and that the state proved it beyond a reasonable doubt before they could move in to the consideration of what are called mitigating circumstances. These are the reasons for life that the defense had presented. And so as she's reading those verdict forms, you heard it live. So this is a jury that said, yes, we agree. We say yes. The state proved beyond a reasonable doubt that this crime was committed in a cold, calculated, premeditated way. It's heinous, atrocious, especially heinous, atrocious, and cruel. Yet we do not think, and we've said this from the beginning, a weighing process. That is a really important term and word when you're talking about a penalty phase. They are weighing each individual juror based on their own life experiences, based on how they interpreted the evidence that they were presented. Did the aggravating factors outweigh those reasons for life, even though they thought they existed? And as we heard, count after count after count after count, the answer being no, which means that in that defense case, and we know what the defense presented, some of the reasons for life was really having the jurors explore what has shaped the Parkland shooter, right? What are some of those underpinning sources for what they said has been a lifetime for him of struggles with, they had argued and their experts had argued, impairments, learning difficulties, aggressive behavior, and they had made a case to these jurors that he never had a fresh shot from the second he was born, that he was quite literally poisoned in the womb, that he suffered neurodevelopment and neurocognitive disorders because he suffered brain damage from his birth mother, Brenda Woodard, who we even had witnesses, a work associate of hers, if you remember Carolyn Deakins, it was the first defense witness out of the gate that said, you know, she saw her abusing drugs and alcohol while she was pregnant with Nikolas Cruz. We have Danielle Woodard, that's his biological half-sister, that she testified that to seeing this and essentially making that argument of fetal alcohol spectrum disorder. That is what their experts told these jurors. And that as he's then adopted by Linda Cruz, and Linda Cruz now has a child that as soon as 3 years old, he's already getting treatment and care, if you remember that, as far back as then, because there are these developmental delays. And they positioned Linda Cruz as perhaps a very well-intentioned mom. She always wanted to be a mother. She was very grateful to have this opportunity to adopt Nikolas Cruz, but that she was inept at the ability of managing what were all of these different symptoms. And I think what's really fascinating is when you get into the state's rebuttal case, you may remember in that rebuttal case, the prosecution had its experts that said all of these signs and symptoms, not fetal alcohol spectrum disorder. Instead, he suffers from antisocial personality disorder. And they really focused on one particular aspect. The defense experts had said a hallmark of fetal alcohol spectrum disorder is impairments to executive functioning. Executive functioning are things like the ability to organize, to plan. And so they pointed to the grisly facts of the case, right? What the Nikolas Cruz was searching months before the shooting, looking up the bell schedule, looking up music good music to shoot people, something he literally searched for. All the planning that went into getting the ammunition and mapping out where he was going. They said this is all examples of executive functioning. Classic, not that, it's antisocial personality disorder. Well, I don't know if you noticed, but yesterday when we actually got to see the final jury instructions, and there were those 40 reasons for life or mitigating circumstances in the jury instructions. Again, jury instructions are the guidelines by which the jury is asked to deliberate, right? It kind of frames their discussion. And in there, it actually discussed a little bit about how one of the mitigating circumstances could actually be the state's rebuttal case, antisocial personality disorder. Sure, they can have both. In fact, we heard that in a pretrial hearing. That was the first time it was telegraphed by the defense that perhaps they're going to make this argument, which they did. We're not saying he doesn't also have symptoms of antisocial personality disorder. We're saying it's both, and that at the end of the day, it's underpinned again by never having a shot the second he even started his life, by already facing that damage in the womb. So the jurors in the case heard all this evidence, and it was their job to consider this all and weigh this.
And Christina,
and say,
I wanted
yes,
Christina, I wanted to ask you this because we talked about how the families and the loved ones were reacting as this is unfolding. The question that I have for you is, there was a little bit of confusion in the beginning just because of the way that jury form was written and because of the way the judge was reading it. So at the very end, we, the jury, unanimously find that the aggravating factors proved beyond a reasonable doubt outweigh the mitigating circumstances established. She said then eventually no for count one, Luke Hoyer, but initially it almost seemed, because she was reading that statement before saying no, there was thinking, well wait, so is it life? Is it death? At what point could you feel in the gallery that the family started to get it? Like, wait a minute, this is going to be life.
Couldn't agree with you more. And also for us as well, quite frankly, because I'm holding the verdict forms that we received from both the state's office and the public defender's office that we were told were the verdict forms that this jury got. And it's actually, the language on here is a little different. It says jury verdict as to death penalty, the beginning part, and then it says we, the jury, unanimously find that Nikolas Cruz should be sentenced to death, yes or no. The language was a little different as well, so we were kind of checking our notes as well. I would say that by the time you get to Gina Montalto, so that's count 3, and if you're watching Janine and everybody else who was joining us, and thank you for joining us, you probably noticed that looking at each other, like, do we think that was what we think it was? And by the time you get to Gina, I think they're catching on that what they're hearing is a recommendation for life. And you might remember that moment when Tony, the father, is in that room, courtroom, and he hears on Gina. And that's a tough one, because remember that Michael Satz, a lead prosecutor, in his closing arguments, there are certain murders that he spoke with the jurors a little bit more about, and his daughter was one of them. I still remember the day that the medical examiner testified about the just egregious wounds. Remember, he was using, he being the Parkland shooter, an AR-15 style rifle. We learned a lot about high velocity bullets.
Christina, we are going to cut you off very quickly.
Destruction that they do.
Christina, stand by. Loria Hadef is speaking right now.
I sent my daughter to school and she was shot 8 times. I am so beyond disappointed and frustrated with this outcome. I do not understand. I just don't understand this. Dr. Allen.
We're inside, right?
I'm disgusted with our legal system. I'm disgusted with those jurors. I'm disgusted with the system. That you can allow 17 dead and 17 others shot and wounded and not give the death penalty. What do we have the death penalty for? What is the purpose of it? You set a precedent today. You set a precedent for the next mass killing, and nothing happens to you. You'll get life in jail. I'm sorry. That is not okay. As a country, we need to stand up and say that's not okay. I pray that that animal suffers every day of his life in jail. And he should have a short life.
It's got to be such a disappointing day. 4 years you've been living this nightmare, and it's just, there's never going to be any closure, but this really wasn't the outcome you wanted.
No, I mean, definitely not. I mean, it's been almost 5 years. We came here today, and it wasn't even a doubt in my mind that this would be the death penalty. I'm beyond disgusted of what happened, what occurred, and again, what is the death penalty for, if not for the murder and killing of 17 people?
What would you ask jurors? What would you ask them if they were right here in front of you?
What were you thinking? This isn't about your personal beliefs. It's not about your religious values. It's about the heinous crime that was committed. There is no recovery. Jail's about rehabbing someone. There is no rehabbing.
Is there any sense of relief that at least you don't have to come to court anymore? At least you don't have to see this guy anymore?
Doesn't matter at this point.
And
we still have to go to the cemetery to go see our daughter.
Do you think there was somebody on the jury, at least one person who, from the get-go, revoked their life, no matter what the evidence showed?
Probably.
Laura, Elon, you guys had to sit there for nearly 50 minutes and listen to them go count by count. Can you tell us what those moments were like?
We sat there for over 12 hours waiting to find out our child was dead. And we just sat there being tortured by another hour waiting.
This idea of the mitigating factors being his mental illness or this alcohol-induced syndrome, that did not outweigh the aggravating did not outweigh the fact that he may have been mentally ill. What does that mean to you?
So that means that everyone that has a mental illness should go on a killing spree? That's what we're telling this society? That we're saying that's okay because you have a mental illness? Mental illness isn't cured. And he had antisocial personality disorder, amongst others, oppositional defiant disorder, but it doesn't give him the right to go and kill 17 children, 17 people. And I'm sorry, this is just not okay.
Were you okay with how the state prosecuted the case? Or do you think they could have done anything differently to elicit a different sentence?
I think the state did a great job. I think they did what they could. We're very thankful for them. Unfortunately, the system continues to fail us.
Would you say today is a tragic day in Broward County?
It's a stain. I'm sorry. It's just a stain, and I live here. It's a stain on this world that we live in. Broward County. It's really just a real
disappointment.
Disappointment.
Have you been robbed of justice? Have you been robbed of justice?
Absolutely. Absolutely have.
So would you say the state let your daughter down?
Yes. The jurors let us down. We have a jury system for a reason, and they let us down. They gave their personal beliefs, but they didn't go by the evidence. There was no mitigating factors. I'm sorry. Any mitigation was disproven clearly in the court. There's no reason. And if there is a reason, then why are we allowing people to just go randomly kill others? Is that what we're telling our society? But there's mitigating factors, a lot of hogwash.
Do you think Cruz should have been locked up long before February 14, 2018, at least in a mental institution or something along those lines?
Locked up, yes. Mental or otherwise, I don't know what the right thing is, but he should have been locked up. He should have been in shackles every time he came into the court. He should have been in shackles the entire time he was there. He's not a human being, he's an animal.
Lori, in the last 4 years, you guys have done so much work, Alyssa's Law, what you've been doing in school board. What does this do for you guys to redouble your efforts outside of the courtroom? I mean, what's next?
So I would say that it just makes the fire inside us even want to fight harder for change and know that we have to do so much more to prevent the next school shooting and work so much harder because this cannot happen. And our nonprofit, Make Our Schools Safe, we have been fighting to get Alyssa's Law passed nationally as a standard level of school safety protection in every school across this country, so that if there is a life-threatening emergency, law enforcement can get on the scene as quickly as possible and take down the threat. Law enforcement needs to do their job. They cannot stand there and just watch as 17 people get shot and killed. Your job as a police officer is to go in, engage, and take down the threat. And if you can't do that, don't do the job.
Lori, the defense lawyers were willing to plead guilty early on for exchange for life. I'm wondering, in retrospect, if all of this was worth it, and not just having that outcome on the side of the
No, absolutely not. He should have been given the death penalty from the get-go.
Will you be, Lori, after what you just said, I assume you're going to be there when Scott Peterson goes on trial?
Absolutely. I just want to end with, please don't show the shooter's face. Stop showing the shooter's face. No notoriety. 17 people were killed. Let's remember them. Remember Alyssa Alhadeff. Remember the 16 others. And you could be a part of helping to stop the next school shooting. Thank you.
Thank you so much. So sorry again for your loss. So you just heard from Lord Alhadeff there.
Okay, you were just listening in. You're joining us now at noon. Janice Fernandez here along with Christy Kruger. We, of course, have been following this breaking story as a jury has recommended life in prison. You just heard from Alyssa Alhadeff's family, and it was gut-wrenching. It was gut-wrenching.
It was indeed. And we're going to turn things back over now. I believe Janine Stanwood is been following all this with our legal analysts. And tell us a little bit about your thoughts after you listened to the Alhadeff family and their anguish.
Well, one thing that Dr. Ilan Alhadeff had asked, and a lot of people, Eric, are asking this, why have the death penalty? If there's ever a death penalty case, if there's ever a case that warrants it, this is it. And all it takes is one juror to not agree, and then it turns the whole thing upside down. That wasn't always the case in the state of Florida. Can you explain that?
In 2016, if this case happened then, or if this case was tried then, it was just a majority. So the law changed. It was called the Hearst case, and now here we need unanimous jurors to come in conformity with the majority of the states that have death penalty. It is majority, so the law changed, and here we are, and that's why this is a recommendation for life, because that is the law in the state of Florida. And if the aggravators do not outweigh the mitigators, if they find the existence of the aggravators and the mitigation, the alcohol-related fetal syndrome in this case, if that outweighs the aggravators when the jury does their analysis, then it's a recommendation for life, and it just takes one. One is all they needed.
But I mean, when you have a cross-section of society like you do, it almost seems like you're always going to have just one. Is that too high of a threshold to require this to be unanimous?
Death is the ultimate punishment. There's nothing in our criminal justice system that you can get a punishment that is more severe than the sanction of death. And understanding what this defendant pled to and what he did, it is the most sincere thing. It is a very high burden. You know, the issue is it too high? I mean, that's a question maybe the legislature will look at. But, you know, when you talk about, is this a case for the death penalty? If this isn't the case, if you have a death penalty, what case is? And you hear everyone asking that because you had children that were murdered, you had teachers that were murdered. But here's the reality. Jurors, when we use that word juror, they're like us. They all come from different walks of life. They have their different perceptions, their different biases. So if you pick a certain jury, and then apparently in this case, while the state did an excellent job, the defense also picked a better jury than the defense.
Here's Tony Montalto. He's about to speak. Let's take a listen.
We'll start off with it's pretty unreal that nobody paid attention to the facts of this case, that nobody can remember who a victim is and what they look like. I know every day because I see my beautiful daughter's face around our home in my dreams, and I miss her very much. I'm going to read you a prepared statement. Today's ruling was yet another gut punch for so many of us who devastatingly lost our loved ones on that tragic Valentine's Day at Marjorie Stoneman Douglas High School. 17 beautiful lives were cut short by murder. Heinous, pre-planned, torturous murder. And the monster that killed them gets to live another day. While this sentence fails to punish the perpetrator to the fullest extent of the law, it will not stop the mission of the families of Stand With Parkland to effect positive change at the federal, state, and local level to prevent school shooting tragedies from shattering other American families.
Tony, what did you think when you were hearing those verdicts being read? As it sunk in that this was a life sentence, not a death sentence recommendation, what were you and your wife Jennifer and everybody else thinking?
Well, I can only speak for myself and my wife since we've talked about it, but I'm sure some of the other families had similar thoughts. How can the mitigating factors make this shooter, who they recognized committed this terrible act, acts plural, shooting some victims more than once on a pass, pressing the barrel of his weapon to my daughter's chest, that doesn't outweigh that poor little, what's his name, had a tough upbringing? I mean, society has to really look and re-examine who and what is a victim. Not everyone's a victim. My beautiful Gina, the other sons, daughters, spouses, and fathers, they were the victims here. Our justice system should have been used to punish this shooter to the fullest extent of the law, not as an act of revenge, but to protect our nation's schools, to stop others from attacking the future of this country when they attack our schools.
Do you not see how it's possible that one juror could have found one mitigating factor?
If one juror was honest when they chose the jury, and they said they could see their way to the death penalty, and unanimously they all found that the aggravators were proven beyond a reasonable doubt, I think that one juror possibly perjured him or herself.
What message do you have to this jury, and does this send the wrong message to the nation? The nation is watching.
Well, again, what do we want as a society? Do we want people who commit atrocious acts against the future of our country to be punished to the fullest extent of the law? Or do we want to excuse them because they had a tough time growing up? I promise you, throughout this nation, there were people who had a more difficult time growing up than this shooter, who have been failed by the school system more than this shooter, and who have had less services provided than this shooter. And they did not choose to enter a school with a high-powered weapon and pull the trigger 139 individual times. That is cruel. That is thoughtful. And that should have been punished to the maximum extent of the law.
We know that the gunman studied other shootings, and now he gets life. For the next teenage gunman or the next young person who decides to get a gun and study and follow, what does a sentence like this do for the safety of other children?
I think that it puts all school children in jeopardy. It certainly sends the wrong message. This shooter did not deserve compassion. Did he show the compassion to Gina when he put the weapon against her chest and chose to pull that trigger? Or any of the other 3 times that he shot her? Was that compassionate? When we heard in his own words what he said regarding other victims, Meadow Pollock, Carol Cochran, Peter Wang. We heard what he said, what he thought. Was that a sympathetic figure?
Sorry, if they have done anything differently, I mean, in retrospect, do you wish they had acted differently either during the case or when they were insisting on going to trial?
I will say that the state did an excellent job. I haven't heard one of our families complain about the case they put on. They were factual. They were realistic. Their rebuttal was excellent. I just think people forget what facts are these days.
Tony, you said this in your statement a little bit, but what does this do for your efforts outside the courtroom? How much work you've been putting in at state, national level? What is this? Does this reinvigorate what you're doing?
Well, Families with Stand with Parkland have always been dedicated to preventing other families from suffering through these horrific tragedies. Perhaps now we'll have to fight to make sure that victim impact statements, real victims, are taken into account. The real victim statements when you go through a penalty phase, so that we can all remember our loved ones, the kind, compassionate, innocent students and teachers that went to school that day and never returned to our loving families.
Are you going to be here for Scott Peterson's trial?
I've had enough of the courtroom for a while, but I imagine that we will come back and do what we did here. We will all represent our loved ones. My wife Jennifer and I will make sure that we represent our beautiful, forever 14-year-old daughter Gina in any court proceeding. We will continue to put forth our efforts to secure her legacy through both Stand with Parkland and the work we do locally, statewide, and nationally, as well as the Gina Rose Montalto Memorial Foundation, which we set up to keep Gina's light shining in this world, because she should not have been extinguished by this monster.
We do live in a country, in a state, in a county where, a sizable part of the population does not believe the death penalty, that they believe that life in prison is fine for. Could you explain
I'll
why?
trade places with you.
Could you explain
I'll
why?
trade places with you. That's why.
Could you explain why?
I've answered it 3 times. Trade places with me, you'll change your mind.
Does this change the way you feel about people in Broward County? I mean, do you feel like the community is letting you down in some way?
Yeah. Gina, my beautiful, kind, bubbly, bright daughter deserved better than she got from the schools, and certainly from this jury, from our sheriff's office. She deserved better. Even from the FBI, who let us down. Let's not forget all the failures that led to this day. But the failures wouldn't have mattered if the shooter didn't choose to pull that trigger 139 times, to make a voluntary effort to pull that trigger, spewing death from that gun every time he pulled the trigger. Anything else?
Thank you so much.
Thanks, folks.
Thank you, Tony. So sorry.
Okay, we're continuing to get reaction from the families of the Parkland shooting victims. They're hearing from Gina Montalto's father. And as you can imagine, we heard from the Aladef family earlier, their emotions right now really angry with the result, from the ones we're hearing right now. And actually, let's go ahead here and listen in to Fred Guttenberg.
I'm guessing you're all wanting me to react.
Yes, please.
I'm stunned. I'm devastated. There are 17 victims that did not receive justice today. My daughter, you'll notice she was the 16th of the 17 to be read today. She was shot running down a hallway. Now, what mitigating factor was it that they used on her? Were they going to suggest that he didn't have the fine motor skill to shoot that gun as she was running down the hallway? This jury failed our families today. But I will tell you, the monster's going to go to prison, and in prison, I hope and pray he receives the kind of mercy from prisoners that he showed to my daughter and the 16 others. He is going to go to prison, and he will die in prison. And I will be waiting to read the news on that. He should have received the death sentence today. There was no mercy for a murder that was planned over a long period of time. And that was, sadly, as proven by the state, executed. I don't know how this jury came to the conclusions that they did today, but 17 families did not receive justice. Because of what happened to our families, we are all in this position now of doing the work that we do around this country to keep this from happening to another family. And this decision today only makes it more likely that the next mass shooting will be attempted.
Tony, Fred, can you talk to us about what you were thinking when you realized that it was not going to get the death penalty?
I looked at my wife and I said shame, anger, devastation. Listen, I've gotten to know you and the others over the years. I've spent the past almost 5 years preparing myself for today, mentally, physically, because I visit my daughter in a cemetery. And the idea that there was at least one juror who I have to imagine didn't tell the truth to get on that jury, and who was never, ever, ever going to vote yes, because they agreed on all the aggravating factors. The truth is, the defense, for those of you who watched this trial as diligently as I did, the defense failed at mitigation. If you looked at the cross-examination, their witnesses fell apart. In the closing argument, the defense team actually referenced the neighbor, the guy who lived across the street, who spent one moment with that killer in their entire time. Okay, they did not prove mitigation, but yet a juror accepted the notion. A juror did not tell the truth to get on this jury, and because of that, 17 families have been failed. And it is what it is. This is the way the system works, right?
Do you think that they should have had maybe the trial outside of South Florida or Broward, if possible, and moved to another venue where you would got a fairer, maybe, or a different story?
I don't know. I'm not a mind reader. I can tell you this. The state did an amazing job of proving the aggravators. The state did everything they possibly could have done. I will also say the defense, to be a defense attorney in a situation like this, I get it, you have a job, but it doesn't mean you need to lose your humanity towards the victims, which they did, okay? And their inability to ever, for a second, either in the courtroom or outside of the courtroom, have a human moment with us, a civil moment, was despicable. Looking at attorney Tamara Curtis take her middle finger and rub it up and down her cheek when she lost an argument in the courtroom, and then to start laughing with the killer over it like an immature punk child, I will never, ever, ever forgive that moment. But that's who they were. So I will tell you, the state did its job. Whether or not doing this in another county would have made a difference, you go through a lot of people to pick a jury. I don't know. I don't know.
What do you do moving forward? I know it wasn't going to bring any closure, and I know it makes your work just that much harder, and you're going to continue working hard. But, you know, him getting life would have been some sort of closure for these families. What do you do moving forward? How do you let go of this anger?
The first thing I do moving forward is I go visit my daughter at the cemetery because he killed her. And that's what I have to do. The next thing I do moving forward is everything I can to prevent the next one of these from happening. The next thing I do moving forward is everything I possibly can to remind people how important the next election is and voting, because we do have the ability to do things in this country to reduce gun violence through our vote, and we need to do them. So I'm going to continue doing what I do, and I'm going to go to the cemetery, and I'm going to tell my daughter what happened today, and I'm going to tell her I love her and always will.
Do you believe in any way a life over death sentence here? What message that encourages or discourages to the next young person who gets a gun out there and thinks about doing the same?
That person is planning a shooting now. Let's face it. And that person now believes that they can get away with it. I'm still, and some of you know me, I'm not often stunned, but I am stunned by this verdict today. And I think anyone planning a shooting right now sees that there's a path to avoid the death penalty where it does exist. And the death penalty does exist, by the way. There was no reason they couldn't impose it. But you know what? His defense counsel in the closing arguments made one of the most bizarre statements I've heard in a closing argument when she said, well, if you don't give him the death penalty, he'll just end up dying in prison anyway, of natural or some other causes. That was his defense counsel who said that. So right now, I'm hoping she got it right.
Fred, is there any sense of small relief that you don't have to go to that courtroom anymore? You don't have to see him anymore?
I would have gone to that courtroom every day the rest of my life to get the right justice. So, no. He did what he did. The only possibility for relief ended for me 5 years ago almost when he shot and killed my daughter. I was prepared for the rest of my life to seek justice, and I could not be more disappointed in what happened today. Anything else?
Thank you.
Thank you all. G-U-T-T? Oh, Guttenberg. Thank you. I'm sorry? No. Sorry.
All right, you were just listening into Fred Guttenberg there. Of course, we're continuing to hear from the family members of the Parkland shooting victims. Lots of anger, lots of emotion. And we understand that. We know this has been a long process. It's been years in the making and months of a trial as well.
And here's Debbie Hickson, Chris Hickson's widow.
Was one of the murder victims. He was the adult that ran into the building to try to stop the shooter to do something to save other people. And I'm just completely devastated and shocked by this verdict to me. What it says to me, what it says to my family, what it says to the other families is that his life meant more than the 17 that were murdered and the 17 that were shot and the thousands of people in that school, in that community that are terrorized and traumatized every single day. Even if every single one of those mitigating circumstances was true, which we all, I think, believe are not, but even if they were, how does any one of those mitigators outweigh those aggravating factors that they all agreed were true? How do you say, yes, it's cruel, that it was heinous, that it was planned, and we all agree on that, but oh, he might have had a mental illness or he had trouble growing up. I have a son with special needs. I have a son that checked all of those boxes, or a lot of those boxes, that the shooter did as well. And you know what? My son's not a murderer. My son is the sweetest person that you could ever meet. This person had services. He had love. He had the best upbringing his mother could give him. But even if he didn't, how does that outweigh cruel, heinous, planned? It doesn't. It just doesn't. I don't care who you are. There's no way that you could look at those mitigating circumstances and believe for 1 second that they outweigh the aggravators and that the life of that person is more important and more valuable than the life of the 17 that were taken and all of the other people that live through that trauma every single day. So I'd like to say I have no words, but apparently I have a lot of them.
Debbie, for those jurors, if they will be watching this later, or do you want to know what went on in that deliberation room? Like, what were their thoughts?
I agree with what a lot of people have said. There has to have been someone who maybe thought they could. Maybe they did. I also believe in grace and giving people the benefit of the doubt. And maybe when they're sitting there and you're asking them questions and they think, yeah, I can do that. But when faced with that decision, that it just maybe was something they didn't have in their makeup to be able to do. But they really should have asked themselves that question harder before they agreed to sit on this jury.
Debbie, yesterday you told me that you thought that if there was a death penalty verdict, that would sort of allow you to perhaps close the door on the anger phase of what you've been through and move on to the healing phase. What are you thinking now?
Definitely that anger phase is going to take a little longer to move through. Because to me, like I said, here I am thinking that they're going through yes, yes, yes on those aggravators. How can you say yes to every single aggravator and then no to the death penalty? Beyond a reasonable doubt, they believe that they proved those mitigators. So it will have to be something I resolve within myself, with my family, because really right now it feels that his life is more valuable than Christopher's, and that is not true. Never.
Ms. Hickson, do you believe that the FBI, the Broward Sheriff's Office, and now the jury has failed your husband's terrorism? Has failed him?
I do. In a lot of those instances, there was an opportunity to stop the shooter before he even got through figuring out his plan. BSO took a long time to get there, and now again someone else believes that someone's life is more valuable than my husband's, and that makes me, I can't even give you the right words how that makes me feel right now.
Is a member of the school board now?
think this makes it more difficult for the schools to stop this kind of event from taking place?
I don't know if it makes it more difficult for schools. We are working very hard to increase our security. It does, and it should say something to society that we have to look at who we allow to own firearms, how we address mental health in our communities, and where we give grace when it's warranted. So.
We don't know how many jurors wanted to go with life.
Correct.
But did you expect a longer, more involved discussion among the jurors to maybe sway others on death, as opposed to the speed at which the jury came back here?
It's a good question. So clearly the aggravators were very easy to go through. I think all of us would agree that 100% were all 7 of them without a doubt completely proven. So in the defense, if you listened to the defense's closing statement, they basically told them that they couldn't, if one person said life, you were done. Like, you weren't allowed to have that. So honestly, I don't know how much of them are, what they're able to do, but it seemed.
The opportunity to engage the other jurors.
Correct.
No, I want you to reconsider. Did you expect more of a debate within that jury room versus the speed at which they came back?
To be honest, I thought it would not take as long, because if you clearly saw the aggravating factors, that mitigating could never, there are some mitigating factors you could check off, but I personally don't see how one single one of them weighs heavier than any of those 7 aggravators. So I thought that it was done earlier or quickly, because they all said, yes, there are mitigating factors, but 100% they do not outweigh all of these aggravators that we did. So shocked at the outcome, but I didn't think it was going to take them a whole long time to do
I have
that.
one other question, which is, I saw you leave the courtroom with your son. You told me in the past the difficulty of explaining to him about his father's death. What did you explain to him today, or how did you explain to him?
Of course, he was very upset, and more, I think, because he felt the room, us being upset in the room. But we just tried to explain to him also that this person is still being punished. So at the end of the day, I've said it a number of times, life or death, our life doesn't change at home. We don't have Chris. Our life, our family is not whole anymore, and we move through the process of how we get through each day. So this doesn't change what happens in our house. It changes emotionally how we feel about society. I think in general, the fact that you could think that someone who murdered 17 people because he had a mental illness, which I don't think any of us would disagree. There's no normal person that's going to do what he did. But that does not outweigh the aggravating factors that were proven in this case.
Debbie, what would you want to say to the shooter today?
I think that he should give thanks to God that someone had grace and mercy for him that he did not share with those other people. And keep in mind, my husband was one of those that he came back and shot again, because Chris survived. He would have survived if he hadn't come and shot him the 3rd time. So I hope that he understands the gift that he's been given. I doubt that he will. But I do hope that he understands what that gift is, and that he's somehow able to take that and do something different than the trajectory he's been on for all of his life.
Did you believe in the death penalty before you got this?
I did not. And I would have been one of those people that would have thought, we can rehabilitate people, that it's not up to us. And it's been a struggle for these last 4.5 years to feel so strongly that this person doesn't deserve to walk on the earth. But you find yourself in a different position and you change your mind. But it's a struggle for sure.
Do you have any thought on why they wanted to see the gun? Did anything go through your mind? Did that signal anything to you? Did you feel it was more hopeful that it would be a death penalty?
Yeah, actually, that's a good question. Yes, because they had just asked about the the cross-examination where they were talking about trigger fingers and things of that nature. So to feel how heavy, remember, 100 and 39 times. He pulled that trigger in 7 minutes. So the idea that he was below average in being able to tap something is clearly not what's reality in this instance.
Do you think somebody wanted to feel the gun and to get an idea?
I would guess so. And, you know, some people maybe just wanted to see it. Who knows? So, anyway, but thank you so much.
Thank you, Debbie.
We also have Broward County's State Attorney Harold Pryor making his way.
Been discussing her struggle really with the death penalty as well, talking about her husband Chris, who she always said that he ran into danger when everybody else was running away. Let's listen in now.
2018, it's forever changed our community. It'll continue to impact us forever. The parents and families of the school children and staff members who were lost in this massacre, our hearts are with them. We hope that they know that all of us lost 17 wonderful people that day, and that our world is a poorer and sadder place without them. To the survivors, please know that you are not forgotten in this, and that we respect and salute your courage and all that you have endured. You know, when I was elected as Broward State Attorney, I promised that I would uphold the law. And I agreed that this community, not one person sitting in the office, should hear all the facts and all the evidence of this case, and that the community should make a decision about whether this mass killer should get the death penalty or life in prison. We thank the jurors for their service, for taking on this difficult task. We thank the law enforcement officers who went into the school. We thank the law enforcement officers who investigated this case and also arrested the killer. We thank our prosecutors and our prosecution team and the whole office for their dedication and service in ensuring that we presented all the facts and the evidence before the Broward County community. And we thank the courthouse staff. We also thank the witnesses. We thank the victims' families and the survivors for everything. As I spoke to some of the family members immediately after verdict, I thank them for their patience with us and their compassion. And I thank everyone who worked to ensure that the whole truth, the full story, was told about this tragedy with full transparency. To my knowledge, this is the first time that the full story of a community's loss and all of the relevant facts have been told about a mass shooting of this magnitude. We have not shied away from telling all of the horror, all of the loss, all of the devastation, all of the pain about this case. We hope that while there's no such thing as closure, there will never be closure. We'll never find closure. But I do hope that this will bring some measure of finality and justice to this terrible chapter.
Mr. Pryor?
Thank you.
Mr. Pryor, question, please.
No questions. I want to allow the families to be able to comment. It's about the families today. And so I'll allow them to speak, and then we'll come back, okay?
We will.
Thank you.
We will come back?
Thank you.
Thank you.
Okay, you're just listening to Broward State Attorney Harold Pryor as we continue to hear from more family members. Looks like we're hearing from Scott Beagle's parents.
In 3 days since the murderer committed the mass shooting at Marjorie Stoneman Douglas High School. And if this was not the most perfect death penalty case, then why do we have the death penalty at all? There's no doubt about the fact that the verdict should have been the death penalty. I believe that our state's attorneys, okay, all of them, all of our state's attorneys, whether it be Mr. Sachs, whether it be Carolyn McCann, whether it be Jeff Marcus, Nicole, Stephen, Aaron, we could have not had a more perfect state's attorney group. No way. Mr. Sachs told me when we first learned that he was taking this case on, he said to me, I promise you that this will not just be another mass shooting. By the time we're finished with this case, every single person who was murdered, people will know who they are. They will not just be a name, but people will know exactly who they are, will know a face, and will know everything about them. And that's exactly what he did. You talk about being disappointed. We are all disappointed, okay? All of us, because they could not have done a better job. They could not have proven their case any better than they did. We all know their case was proven. But again, we have jurors, and there's no doubt in my mind that somewhere along when they chose their jury, they had to be told, I'm pretty sure, that they would consider the death penalty. Somewhere along the line, one of those jurors had to have said, I know he committed these crimes, I know he deserves to be punished, but I can't be the one to put someone to death. And that is the only way that we did not get the death penalty. My son was murdered along with 16 other people, and this animal, okay, still is going to now have life in prison without parole. And let me tell you something, as far as I'm concerned, he's probably going to get taken out sooner than later if he did get the death penalty. Because we know that a death penalty case, I believe in Florida, takes a lot longer. I think it's somewhere, the average is somewhere close to 18 years, okay? I'd certainly be dead and buried before he would be. So as far as I'm concerned, the fact that he's going to go into some sort of general population, he's going to have to look over his shoulder every minute of the rest of his life. Just the way the fear in him, I hope he has the fear in him every second of his life, just the way he gave that fear to every one of our loved ones who he murdered or the students and people that he harmed. He should live in that fear, and he should be afraid every second of the day of his life.
Just to add, okay, about fear, this is what my son saw. He saw the gunman as he turned and pulled the trigger. This is what the jury didn't think was worth capital punishment. Answer me why, how, that my son be shot by this animal like this. People need to see this. This is real. This is not a game. This is not a video. This is not a TV or a movie. This is real. The last thing my son saw was the gunman aiming at him.
And let me tell you something, we're not going to stop. I'm going to tell every single person here, we will never stop fighting. We are never going to stop fighting so that these animals can't go into, whether it's schools, movie theaters, places of worship, you name it. We're going to fight with them so we don't have to keep looking over our shoulder and wondering when we send our kids to school or our loved ones go to work at school or go to work anywhere, okay, that we could possibly never speak to them again. We're going to continue to fight, and we're going to make sure that AR-15 and those assault weapons that killed our loved ones are taken off the streets. And that's what we are going to continue to do. Because this should not happen to anyone else. This should never happen. We should not have to worry about, even ourselves, walking around the streets that somebody's going to murder us with a gun that they illegally own or illegally own and have gone off the deep end somewhere and decided that they're going to take their anger out on someone else.
And this verdict today gives license to anyone who wants to claim they have a mental illness to kill people.
Sure, all I have to do is have a mental illness, not a problem, okay? One of my attorneys is going to do a mitigating factor that I'm a human being, okay? That's one of the mitigating factors. He's a human being, okay? And that gives him license to, him or her, license to go in and kill people. This is ridiculous. This should be the case that makes people stop and say, oh my God, I better not do that because I can get the death penalty. This is the case now. You know what? I can do it, not a problem, and I can get off and I can have life in prison without parole.
Do you believe that one juror or more lied to get on this jury?
I won't say lied.
No.
Maybe when they were originally questioned, they thought they could do it, but when push comes to shove, maybe they realized that they couldn't.
We can't damn the jurors. Come on. I mean, if that's how I come across, I apologize. These jurors sat there since July 18th, day in and day out. Let me tell you something. They're the people that we need to that we need to give therapy to, because here they are. They watched. They went into the 1200 building. They saw all the autopsy photos. They saw some things that we never got to see, and you certainly didn't get to see. I mean, they did their job. There's no doubt about it. But when push came to shove at the very end, like all of the aggravating factors, they all checked them all off. There was no doubt about that those aggravating factors were all checked off.
Some of the other parents did seem they were lashing out at.
I'm sorry, I can't. It's going to have to be one at a time. It's hard enough to hear one. I'm sorry?
Your husband once wrote in the Sun Sentinel about having to sit through this and relive it.
This was 3 years ago. This was yeah.
How do you feel about it now that you've gone through it?
3 years ago, I didn't know a third of what I know through the trial. If I knew what I know now, back then, I would never have said what I said. Okay, this animal deserves to die. He hunted all these people. He planned this for months. I didn't know that he had planned it for months when I wrote that article. No, I take back everything I said in that op-ed. He should die.
And you mentioned that some of the parents who preceded you did seem like they were very angry, lashing out at the individual jurors. But you're saying that you don't believe the jurors themselves are at fault. And do you have any sort of understanding of how one of them could have found a mitigating factor?
There is no mitigating factor at all that could overshadow, the aggravating factors. There are just none. And I'm not sure, I mean, I can't speak for them, but I'm not sure that, maybe an hour after we were all let out of the gallery, that people's emotions didn't come out in ways that maybe, I'm not sure that it's really anger at the jurors. It's anger at, it's anger at the sentencing. It's
anger at the system.
Yeah, it's
okay?
anger, really.
It's really anger at the system.
You can't go after a juror. They did their job. They went day in and day out. It's not easy. But, you're totally anger at the system. I mean, I know we have a legal system, but is it just? I mean, let's ask ourselves that question. We certainly do have a legal system. I'm not sure it's so just all the time.
Justice was not served today.
We saw you looking at your son's picture in the courtroom. Moving forward, now feeling that justice may not have been served for your son. Is it any different for you when you look at that picture? I know there's no closure, but now are you even more angry or?
There's never closure, okay? This is a chapter that's closed. I'm not sure of the epilogue yet because I haven't really been able to process. It's a chapter that's closed. I'm never going to get closure. I'm never going to get my son back, whether it was the death penalty or life in prison without parole. Scott's not coming back, okay? That's just the way it is. A little aside, if you notice, when they were talking about Scott and she was talking about the counts, they had a little bit of tumult, That was my son. There's no doubt that was my son telling us, you know what, Mom, I'm here. But as far as closure, there's no closure. There's no closure when your son is murdered, okay? There is not. And for me, the anger stays here. Every once in a while, the lid gets taken off, but the anger stays here. The anger is always going to be here. And I'm going to tell you something. I never thought that I could be so ugly inside, but I wait and welcome the day that I get that call that tells me that that murderer was murdered in prison. And that's going to be a very happy day in my life.
And just one more thing. They talk about the victims, the 17 people who were killed. Every person in the Parkland community is a victim. Everyone. So don't play that down at all, okay? On February 14th, 2018, everyone here was a victim. February 14th is also my daughter's birthday. Imagine how we celebrate or don't celebrate her birthday. Imagine the fact that some of her friends don't like to call her on her birthday because they didn't know what to say. My birthday is February 16th. I was making funeral arrangements for our son on my birthday. Everybody is a victim. There are no survivors of a mass shooting. There's different levels of victimhood, if that's a word. Thank you.
Thank you so much.
Scott Beagle's parents give their reaction, and now we are listening to Chen Wang.
Chen. I'm Peter Wang's cousin. I'm here with my aunt, Linda, over there. We are just shocked by this result, and it's just so unjust. I think many people, we thought there's a very clear cut. This monster killed 17 people. Like, how can that be? How can he live another day? And I feel a lot of jurors or the public do not really consider the factor of what happened, to the families, to the moms. My aunt has changed forever. She suffers from PTSD, and she constantly have hyperarousal. She cannot function normally. She cannot sleep, the constant insomnia. And we came here and thought that we could get a little comfort for my family, but no, they just pushed them further. And not just my aunt, all the moms that I saw in the fucking courtroom, they are suffering, and this result made them suffer even more. All the moms, now they are saying, okay, I guess this murderer who can murder my kid and still be alive. All their dads. They have to live knowing the fact that the murderer is in the jail every single day, breathing, eating, and getting help by their lawyers. Well, their kids was murdered on that day, and also, they were murdered they got multiple shots. The shooter came back, and they are saying all the excuses about mental illness, not getting proper help. The murderer came back and repeatedly shoot at all the kids. What about the kids? What about the families? It's not about the shooter. Why can't they do something that's helping them? Also, in my knowledge, there have been at least 4 students committed fucking suicides. Suicides, we're not talking about that. These parents who are of these suicidal kids, where is their courtroom? That one juror or more made this decision, but the whole system do not know there's more people gonna die. Suicide, more school shootings. This is insane. Right? Everyone knows, right? This is insane. We need justice. All of your kids need justice. All of your kids in school. And now more people are getting motivated to do this shit. My aunt's dying. This monster literally said, I'm not going to say it, but he was happy to see people dying. He had a little smirk on his face today. We have been quiet. We've been trying to follow the law, believing the system would help us, but it didn't today.
We first want to say that from hearing from the families, we know there's so much emotion, there's sadness, there's anger. We have heard some language that we want to apologize for. Of course, we can understand their emotions right now, but we do want to apologize for that language that is being aired right now. It's something that is out of our control in a sense here.
Right now, we're listening into one more family here before we go to ABC News and the insurrection hearings. Let's listen in.
Spending months. So today, I believe justice was not done after spending months and months listening and hearing testimonies and looking at the murderer, his composure. I believe justice was not done. The wrong verdict was given out today. First, I want to thank Mr. Sachs, Carolyn McCann, Jeff Marcus. They worked and worked tirelessly for us to get or to find out today that we have been let down by the jury. I'm sorry, 17 people died. 14 beautiful children. 14. 3 adults. 3 adults dedicating their lives to educating children died. And today we find out there's no justice for us. If this murderer had mental problems, he still managed to get a gun. He still managed to get an AR-15 to mow down our kids. Why was he allowed to get an AR-15? President Biden, it's been 4 years and I've listened to countless shootings, one after another, traumatizing my family, traumatizing our neighborhood, traumatizing Parkland and Coral Springs. And today, the wrong verdict was given. Someone killed 17 people, attempted to kill another 17. And we let them get away with it. We should have had the death sentence given out today because he took 17 lives and he attempted to take 17 more, and it could have even been more. And he planned it meticulously. And now you have sent the message out there to everyone. It's fine, get an AR-15, get a semi-automatic weapon, and you will just get off by pleading that you're insane. It's the wrong message. It's been years and years and years listening to the news, hearing nothing but shootings in this country. And today we let someone off that murdered 17 people in cold blood. How do you describe someone dying as bursting open their head? What kind of people are we? There should be an automatic penalty for someone that does that. All the 17 families are so angered. We had to listen to how he just came back and finished off our loved ones. There is no excuse in this country to have weapons of war on the streets. And if you do not get that, then something is wrong in this country. And there was one person with a gun on the school premises that day that my daughter died, and he did nothing to go into that building and to tackle that murderer. And I'm sorry, I have to say, as a black woman, I have to sit there and listen to black men being shot multiple times over and over again. And this animal killed 17 innocent, beautiful kids and 3 dedicated teachers, and he got away with it today, as far as I'm concerned. Anyone that listened to the testimony over these past months can see that he planned it, he executed it, and he just waltzed out of that building.
Do you believe that if you had been black, the outcome would have been different today?
Black men are mowed down. Innocent black men are mowed down all the time. The attitude towards kids, black kids in school, it's different. I don't want to make this a racial thing, but from my experience, there's more aggression towards black kids. So, I don't know. I can't say anything about that, but maybe Scott Peterson would have gone in and taken him out. I don't know.
Ms. Grant, do you feel like the state let you down, not the state attorneys, but the state of Florida, the jury system, the justice system?
Everything. We moved from England, we came to this country. My daughter was a bright young girl. She couldn't even get into the gifted class because she was shut out. How do you get 100% on the test and get shut out? Everything in this country is just so wrong. Something needs to change. We need to do better. We need to do better.
What was it like to be sitting in there? You had to sit for 50 minutes listening to every single time, hearing everyone's name, and it just, what was that like, those 50 minutes?
I didn't even listen to when the medical examiner was, I wanted a picture in my head of Helena, how bright, how beautiful, how fun she was. I didn't want that ruined by the murderer. The murderer has put images into all of our heads of the disgusting thing he did on that day. That's all I can say.
I take it you're going to be at Scott Peterson's trial?
If I can manage it, I don't know. This has been so exhausting. It's gone on for so long. Right now, I'm drained.
But you do hope he gets convicted for what he didn't do?
Yes, people are making excuses. Scott Israel said that he didn't have to engage. Why do you put that badge on? Why do you put that badge on if you're not going to go in and protect children?
Do you have any views on what happened with this jury? Not the aggravators, but the mitigators, do you have any views on the process or what could have happened?
I feel that the jury was convinced at the end when when the defense team, especially the lady, kept on talking about soul. Oh, he had, you're going to have to think about this for the rest of your life if you give him the death penalty. They try to guilt trip, but they're not realizing that we have to live with this. We have to live with not having Helena in our lives. He is nothing to us. He's a monster. He doesn't deserve, as she said, grace and mercy. He doesn't deserve any of that. He's allowed to breathe, gets 3 meals a day. Where is my cousin? She's not here. I have to see my family go through the hell of this trial. We keep quiet because we're saying, okay, the system is good. We're going to get justice. It's obvious. 17 people, 17 children. And you cannot just say, give him the death penalty. This is going to be what's precedent?
Yes.
Because basically, they can just say, well, look at this case. He shot up 17 people. I only killed 1 person. Why should I get the death penalty?
Yeah, I can pretend.
I'm crazy. Oh, and then they were talking about the mother was drinking, and that's why, because in the womb, he's that way. There's plenty of people that have drunk and had kids, and they didn't turn out into killers.
Mass murder.
Mass murderers.
I want to go deeper. As you know, February 14th in general is a national celebration. You've heard from some that have said that, she had to deal with a sibling that died on her birthday. My uncle, that's his birthday. His daughter died.
On his birthday.
I had to deal with carrying my daughter in 2018 and delivering her in June, knowing that my aunt no longer has her daughter. It's not okay. And so now we walk away with, especially for those who work in the school system, my mom's been a teacher for over 15 years. Why should I give my life to a system where I have to now be cop, teacher, defender? Why? You're not paying me enough for this. The sacrifice and the burden that we've put on the school system by not rendering justice is huge. Who wants to lay down their, obviously you're going to do what you want to do, you're going to do, but it's a heavy burden that you're leaving and a heavy weight that you're leaving on these families. My daughter is 4, never got to meet her cousin. And this is how long this has been taking. And then today, to hear that, okay, well, he won't get parole, but he's going to just be able to be alive is more than discipline.
Michelle Thomas.
Michelle Thomas.
My name's Sefina, Sefena Cooper.
Thomas.
Thank you.
Okay, we just heard from Helena Ramsey's family there, very impassioned statements given by the family. And I believe we are waiting for the next family member to come up, which should be Max Schachter. If you were watching in the courtroom as the verdict was being read, visibly emotional. He definitely had a reaction when he was hearing it inside the courtroom, as many did.
Exactly. He was shaking his head, just surprised, shocked by what he was hearing, evidently. And we're, again, waiting to hear from him and some other family members.
Oh, and it actually looks like we're not hearing from Max Schachter right now, but let's go ahead and listen into the next family that's going to speak.
Good afternoon. I just want to start off by saying thank you to the prosecutors. Every single one of them were beyond excellent. I never thought I would be in this position, but here we are, and we couldn't have asked, I believe everybody is in agreement, to have a better team than the team we have. We are in shock, disgusted, something that is supposed to be extremely common, as all the other families have mentioned. How is this even possible? How are we standing here right now with this verdict when it should have been clear as day, extremely transparent, a death sentence? They've said it before, I'll say it now. If not now the death penalty, then when? When? And there is no excuse, nothing the defense said. Nothing. Absolutely nothing. It shouldn't have been a case at all. No excuse for letting this piece of garbage breathe.
Well, here we are again, under these circumstances. We weren't expecting that this will be the verdict. The defendant accomplished his goal. The defendant made us feel bad, took us, our loved ones, away. The defendant saw the family suffering. The defendant fired 139 times, and he didn't do more because he didn't find anybody else to keep fighting. We are in a state that the death penalty is an option. After seeing the massacre that he did with all the 17th, plus other 17th, that they're crying and they're suffering, plus the entire community of Parkland, the entire community that belongs to Marjorie Stoneman Douglas, that they live with this pain, every single moment they're triggered with sounds is not served by death penalty. Why we have the death penalty as an option here in Florida? What is that for? That is my question. I am very proud to be having an amazing state team. They gave their passion. They came back from retirement. They believe that the justice has to be served. And it wasn't. I knew it wasn't because of them. It was because of one person wasn't agreed with the result. I can thank the jury. They were coming here day by day, as Linda said. But that was that person who disagreed, and he made that difference. And today we don't have the justice served because of that. That's very unfair. That everything has to happen just for one person that decided not to happen. So now we gotta keep going and we gotta keep living, and we have to work our best to find our peace. We're not gonna let the defendant take more from us that he's been taking during all this time. I hope that you all respect our moments. This is something that we have to digest. We need to live with this new reality. We're ending this chapter. We are going to open a different one. We're not going to let that defendant take more away from us. That's for sure. And that's my advice to every single kid that was injured and they were lucky to be here today. Don't let the defendant take more away from you than he already did. So thank you for being covering all this time. I hope that you don't forget that this situation keeps happening every single day in the entire nation. And we need to serve justice everywhere. And everywhere, everybody needs to get the attention they need, because these situations are very painful for all of us. Mira, la sentencia de hoy fue algo que realmente no estábamos esperando. Las leyes de la Florida dan como opción la pena de muerte.
That is Patricia Oliver. She's just answering some questions in Spanish right now. Of course, her son, Joaquin Oliver, his father has been a big face in this movement.
Right. Manny Oliver, of course, very, very vocal, but has said repeatedly that he would be absent from the court because his emotions are just running too high. So he was letting his wife and his daughter speak for him. But he has been, as you've mentioned, we were sitting here looking, he has been tweeting quite a bit, also voicing the disappointment in what the jury's decision was, and disappointment in the system, but not in the state and not in the prosecutors. To a person, each of these families has praised the prosecution and that team for the job they did. Their disappointment is more along with the jury.
And we actually want to quickly just switch gears and play back some sound from the jury foreman that we were able to get, and we want to go ahead and listen in on that. I believe we have that right now.
You know, we went through all the evidence, and some of the jurors just felt that was the appropriate sentence.
Your feelings about this as the jury foreman that went this way?
Like I said, you know, I didn't vote that way, so I'm not happy with how it worked out. But everybody has the right to decide for themselves. It is a moral decision on their own, and if some of the jurors just felt that way.
How hard was it working, serving on this jury? The length of time?
Oh, it was awful. It was awful. I mean, things you know, a lot of things you never wanted to see and you never want to see again. It was, you know, like, don't get me wrong, the people at the courthouse were great, you know, the judge was great, I mean, the lawyers were great. It was just really hard subject matter.
Do you think, does it hurt you that people are being critical of this decision because they were not inside the jury?
Everybody has a right to their opinion. I mean, like I said, it didn't go the way I would have liked, the way I voted, but everybody has the right to their opinion, and that's what happened.
Why did they come back so quickly? Last question. Why did they come back so quickly? It was pretty, you know, some people were surprised by why he came back so quickly.
Well, I mean, we had a full day where we went through it like that, and then waited overnight for people to sleep on it. And then, you know, if a juror has a hard that they're only going to vote one way, there's nothing else you could do. So we voted and we moved on.
Can you talk about when you were, you know, watching the families in court today and just how that was for you, sitting and hearing this being read off and watching their faces?
You know, I don't know if you could see my face, but it hurt. You know, I feel bad for them. It hurts. You know, it's... Well, like I said, there's nothing we can do. It's the way the law is, and that's how we voted.
Would you serve on another criminal case again? Would you be jury foreman again?
I'll do my civic duty if I'm called. I don't know what else I could say but that. You know, I hope not, because This has been, really hard on my heart, and I'd rather not have see something like this ever again.
Was there any arguing among jurors about this?
I mean, differences of opinion. I don't think there's, if you talk about, fighting, no. But, everybody had a strong opinion, and we talked about it. We went through the evidence. And at the end, everybody had to make an individual choice.
Okay, can I get the correct spelling of your name?
You were just listening to the jury foreman, and Christy, from listening to him, I think what's very interesting is that he said some of the jurors really believed in that life sentence recommendation, and in a lot of those cases, it seemed like they were not going to be swayed.
And also, interesting, we keep hearing from the families, it only took one juror, but he said jurors plural, that
Correct.
Several jurors have that opinion that it should be life in prison without parole rather than the death sentence. This right now is a tweet from Mac Schachter that we want to read. Prior to this shooting, the Parkland murderer said he wanted to kill 20 people. He stopped after killing 17, including my sweet little boy, Alex. Afterwards, he didn't want to die. He wanted to live, and today he got everything he wanted while our loved ones are in the cemetery.
Yeah, it's gut-wrenching. It's gut-wrenching to read that. It's been hard to listen to the families. Of course, this is something that happened back in 2018. We have been covering it. And of course, the months-long trial, it has not been easy for these families to get up and give those impact statements. And no doubt it is not easy for them to go up to the podium and give their reactions to what they're feeling, which is anger, which is sadness. No doubt they are overwhelmed. No doubt they're going to be processing a lot of those emotions. But one thing I think has been the overall theme is that all these families do believe that there needs to be changes. They're not necessarily blaming the jurors. And I think it's important to note, the foreman mentioned that these jurors had to listen to testimony. They had to listen to the impact statements, but also those gruesome details, as well as surveillance video that we did not see, but they had to, and walking through that building.
And they walked through that building. And those are images that will stay with them for the rest of their lives as well. We are going to continue to follow this throughout the afternoon. We will be, of course, listening to any other family members who want to have their voices heard. But right now, we're going to throw things over to ABC News because the January 6th hearings are also underway right now, and ABC has special coverage of that. And we will join you later on this afternoon with more.
On the advice of counsel, I respectfully decline to answer your question on the basis of the Fifth Amendment.
And Mr. Stone, did you have any role in planning for the violence on January 6th?
Once again, I will assert my Fifth Amendment right to decline to answer your question.
Although we don't yet have all the relevant records of Roger Stone's communications, even Stone's own social media posts acknowledge that he spoke with Donald Trump on December 27th as preparations for January 6th were underway. In this post, you can see how Roger Stone talked about his conversations with President Trump. He wrote, "I also told the president exactly how he can appoint a special counsel with full subpoena power to ensure those who are attempting to steal the 2020 election through voter fraud are charged and convicted, and to ensure Donald Trump continues as our president." As we know by now, the idea for a special counsel was not just an idle suggestion. It was something President Trump had actually tried to do earlier that month. We know that Roger Stone was at the Willard Hotel on January 5th and 6th, and we know from other witness testimony that President Trump asked his chief of staff, Mark Meadows, to speak with Roger Stone and General Michael Flynn that night. In addition to his connection to President Trump, Roger Stone maintained extensive direct connections to two groups responsible for violently attacking the Capitol, the Oath Keepers and the Proud Boys. Individuals from both of these organizations have been charged with